Good morning, everybody. Happy Thursday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia. We're going to jump right into the deep end. Judge O'Donnell.
Present in court is the defendant, who's accompanied by his attorney, Mr. William Watson. We were previously here on June 3rd, 2026. At that time, the defendant withdrew his previously entered pleas of not guilty and entered a plea of guilty to count 1, having weapons while under disability, a felony of the 3rd degree, along with a forfeiture specification. This matter was deferred for sentencing and referred to the Lake County Adult Probation Department for a pre-sentence investigation and report. That report has been prepared. The state has had an opportunity to review that report and is ready to proceed with sentencing. The state would move to dismiss the remaining counts of the indictment, and there are 81 days of jail time credit. Thank you.
Mr. Watson.
Thank you, Your Honor. May it please the court. I'll be brief. I mean, there's little to say with Mr. McCoy's history. I know it's bad. Mr. McCoy is a troubled young man, Your Honor. I believe he just turned 21, and he's had a rough life, and he's been homeless. He was currently homeless during the pendency of this case. There were preliminary hearings set out of Willoughby Municipal Court. He was in contact with me off and on. I mean, his phone, I believe, was turned off one time, again because he was homeless. But he did make attempts to address this, and I believe he turned himself in on this case. There was a warrant outstanding for him. I believe he turned himself in. He wanted to address this issue. I just spoke with him. He wants to address the pending issue downtown Cleveland. Your Honor, he wants to turn his life around. He's been sitting here for over 80 days. He's told me numerous times that he's sick of where his life has ended up, and he would like a change. I know, Your Honor, based on his history, that it's a long shot to ask for probation, but I do think a place like NeoCap would actually benefit Mr. McCoy. I think that type of a program was made specifically for people like my client here. I don't know if the court will consider that at all. Mr. McCoy would welcome an opportunity from this court if it were to consider that. In the alternative, Your Honor, I would simply ask the court to consider his age, the fact that he's been homeless, before imposing sentence. Thank you, Your Honor.
Okay, what do you have to say?
Stand up.
I have no excuse good enough for the actions which have put me before you here today. During these past few months, I've had nothing but time and constant reminders from my family to think back on those actions and be the loss of words for my ignorance. Of course, I'm remorseful, not only for my actions, but for letting down the people who were and still are rooting for me. One of the people being my own son, who asked when I'm coming home every time I call. I am ashamed. I worked hard, found a great job, as well as amazing people who cared for me, offering help and advice on how to live a happy life, a better life. If you were to ask me what I think my sentence should be today, I'd say whichever way I could get the best help and guidance. I want better for myself, and I'm willing to work for it. I'm willing to complete a probation, attend AA meetings regularly, and cease all drug and alcohol consumption completely. Though if you feel that prison is the answer today, I will not give up at that. I will enroll in programs fitting to me, obtain my general education, and attend classes or groups regarding abstinence. I have not made a mistake too great to affect the rest of my life negatively. I can overcome the setbacks, and I will. With that being said, Your Honor, I apologize and thank you for being heard.
You pled to a robbery in Cuyahoga County, November of 24. This says he was admitted to prison. How's that possible if the disposition was in juvenile?
Your Honor, he did get admitted to prison and then was returned to Cuyahoga County Juvenile Court after approximately a month.
How is that
How
possible?
long were you there?
Don't know, but he was admitted to
You were in
Lorraine
Lorraine
Correctional.
for 2 days, and they sent you back where? County jail?
Yeah, I wasn't supposed to be on the transport list.
Your Honor, my client just said he was transported from Cuyahoga County Jail to Lorraine Correctional Facility. He was processed there. He was there for 2 days. According to my client, he was not supposed to be transported there, and after 48 hours or so, they transported him back to the Cuyahoga County Jail.
All right. So then you went over to juvenile court. You were released I don't know when. When were you released from juvenile court?
December 18th.
All right. And what did they have you do over at juvenile court?
Nothing.
Nothing. Why not?
I'm not sure. They just released me.
Where did you go when you were released?
I went to stay with my mother in
Where?
East Cleveland.
And how long did you stay there?
I stayed with my mother about 5, and then we ended up going hotels.
And how long did that go on?
Until I turned myself in on this case.
You list you say you were employed with 1-800-GOT-JUNK from May of 25 through March of 26 when you got arrested. How'd you get that job?
My sister's boyfriend got the job there. He moved up from South Carolina, got the job, and he was good friends with the general manager at the time. So he got me a good position.
What did you do?
I'd go to people's houses, like book appointment. I'd go to their house. I'd quote them the job, and then if they want to do it, then I'd carry it out.
So you would follow up on a lead they got? Somebody interested in the service? Or what?
Yeah.
Okay, so you got this charge in this weapons charge in Cuyahoga. You're hard to keep track of here, you know that?
Yeah.
In December of 25. What's going on with that case?
I was told by my public defender downtown that the case was supposed to be thrown out because it's called a necessity. But for some reason, they're still trying to get me on it, get me down there.
You've had a pretty, what are you, 21?
Yes, sir.
You've been in more trouble up to this point than most people are in their life. Why is that?
I don't have any set answer for that. I can't really blame anybody but myself. I get into a lot of things that I shouldn't. Even when I'm doing right, I still find myself doing things that I shouldn't be doing. I don't know.
Who were you? What were you doing this night that this thing happened?
I was on a job and I found some silver and gold, so I came out here to a place that I've dealt with before.
What do you mean you found it?
In a clean out in a basement. It was like some 14-karat gold necklaces and silver bullion. So I came out here to a silver shop. Well, I also found some forks, so I went to an antique place in Wycliffe, I believe. And
What do you mean you were cleaning out? What were you cleaning out?
it was a basement to an old house that they were renovating.
Was that your stuff to take?
It was trash. It would have been thrown away regardless. I mean, there was nobody lived in the home.
Okay, so you found this stuff. Who were you with that night?
So I took two of the guys that worked with me. They weren't there when I found it, but I took them with me out here, or to Wycliffe rather. And then we were on the way back when I got pulled over.
Okay. Why did you come out here to do it?
Because I've dealt with the place, the gold spot I've dealt with before, the pawn shop rather. But I looked up Wycliffe's antique spot to sell the silverware.
Yeah, how much you get for all that stuff?
The silverware I didn't end up getting anything for. It wasn't worth.
What about the other stuff?
I ended up getting like $350.
Okay, so where'd you go from there?
We stopped at the liquor store and got a bottle of tequila, and I was driving back to Cleveland.
Going 102 miles an hour?
Yeah,
What time of night was this?
it was midday actually.
Midday? 100. Why were you going 102 miles an hour? Were you begging to get stopped?
I don't know.
I mean, that was pretty stupid.
Yeah,
Of all the stupid things you've done, why don't you just put a target out there? Just paint your car lime green and say, stop me, I'm going 102. Were you drunk at that point?
yes.
Okay, there's another good idea. So how is it possible, how is it remotely possible that you're going to straighten your ass out?
I'd ask for some type of program or
What kind of program? What do you need a program for?
something to help me stay straight. I mean, when I was just released out there, I just fell back into everything. I feel if I'm drug tested regularly and stuff's held over my head when I'm out, like a slow re-entry.
You said at the start, when you read whatever you wrote, you were talking about disappointing, letting people down. Letting what people down? Who?
I have a best friend of mine. Well,
Who?
his name's Devin Towns. He actually owns his own clean-out company. And I started working for him when I was 15. I met him at the DMV. And he's been in my corner ever since then.
How do I know he's not one of you guys? Because you've been hanging around people. Apparently, you've been hanging around people that led you to a shitload of charges through your young life. So how do I know this guy's not one of those people?
Well, a lot of the guys that have hung around were younger, my age, doing those type of things. He's not. He's he's double my age. And like I said, he owns his own business. So the only thing he does all day is clean outs or pass out cards.
Okay, who else?
Well, my family, my
Who?
mother. My mother, even though she has problems of her own,
What kind of problem she have?
she's an alcoholic, and she has bad problems when she drinks. But she's always been in my corner, no matter how messed up she was. My sister also.
What does she do?
My sister,
Yeah.
she just picked up drinking, but she was never really into drugs or alcohol. But
How old is she?
She's 20.
She just picked up drinking.
Yeah.
What did she see what you're going through and figure that's a good idea?
My mother should be enough.
Where does she live? With your mother?
My mother, actually, they just got into it, and she put my mother out. So my mother had another episode, but my sister has her own apartment on the west side of Cleveland.
Okay. Who else?
Well, my child and his mother, though I'm not with her, I still keep in contact with her a lot.
What's her name?
Her name's Ashanti.
Where does she live?
She lives in East Cleveland.
And your son lives with her?
You know, my son stays with my mother. Well, not my mother
Jesus,
now.
that's not a good idea, is it?
No, he stays with my sister. But my mother was taking care of him when she
How
was
old is he?
4.
How the hell is he going to get any proper care?
Me, I mean,
Jesus.
when I
Who was caring for you when you were 4 years old?
my mother was.
Okay. Is this another Junior Isaiah we got coming up, or what?
I'm trying. I would try so hard to stop that.
Who else in this circle of people you were talking about?
Well, I just started talking to my uncle again. He disassociated himself from the family for a couple years, but growing up, he was more of a father figure to me than his brother was. So
Where's your father these days?
my father's bounced all around. He's settled down with a woman in Nashville. He got a house, but he doesn't care about any of his other kids other than the 2 that he has.
Where's
with
his
her.
brother live?
He lives in Menor on the Lake. He just bought a house in Menor on the Lake.
What does he do?
He's a mason.
And who else?
That's really about it.
Okay. So what you talk about programs? What programs? What programs do you need to get your shit together?
Definitely like alcohol, like a probation to keep, to keep me sober, to have something over my head, to not.
What happens when there's nothing over your head?
It's free. I don't have anything to hold me back from doing it.
That's right. Unless we put you on lifetime probation. So when you were working at this place in Bedford, how much were you working?
I worked in the summertime 12, 13-hour days, like probably get 85% of the time, but it slows down in the cold season. But even then, I'm always there. I'm one of the guys, and no matter what's going on, I'm there. Rather, if I'm in the yard, because we have a little dump yard on the side, if I'm just there running trucks to the dump or out on routes doing jobs.
How can you drive if you don't have a license?
I really wasn't supposed to be driving, but I wasn't toward the first GM. He didn't care, so I was, but he ended up leaving, and some higher ups came in and cracked down.
Why don't you have a license?
Actually, when I got out, I went to a juvenile intervention driving course that I was sentenced to from Geauga. I completed that. I obtained my temporary permit, but I was driving in Barberton with a person. He told me he had his license, but I got pulled over, and turned out he didn't have his license, and I had a temporary permit. So they took my truck, and they put another indefinite suspension on my license.
What exactly is it that you want to do with your life?
Career-wise, I'm not too sure. A lot of things I feel I'm good at. I just want to get away from this stuff.
What's that mark under your right eye?
From the robbery that I was convicted of was actually started off as a murder. They charged me with the murder of my best friend because we were buying a gun when we got robbed, and they shot and killed him. And then I ran to Georgia, and I ended up coming back up here to be with my son and just face the music. And then a year later, it resulted in a robbery. And I got this mark 3 days after he died. I was 17 and drunk.
Okay. Why did you get it?
Because it just symbolizes a loss. sir. You know, it can either mean you killed somebody or you lost somebody.
So you think that's a great idea going forward?
The tattoo?
Uh-huh.
Oh, no. I was 17 and drunk.
Okay. What are you going to do about it?
I've been reading into laser removals, but that'd come sometime down the line.
You list this address in Willowick. Whose house is that?
Oh, that would be another person that's rooting for me. My Aunt Holly. It's my father's adopted sister. I stayed with her when me and my mother did get into it at the hotel one time, and I left. My Aunt Holly always wants me. She wants me to stay with her, but her husband's like he just doesn't really care for her side of the family.
Can you blame him at this point with everything you've been telling me?
I mean, he has his own problems with.
All right. Well, everybody's got problems.
Criminal.
You guys on the your side of the family are lighting it up so far.
Yeah.
So at some point, whether it's now or 3 years from now, you're going to be out. Where are you going to go?
I don't know. Hopefully my mother gets her stuff straightened out, so I could have somewhere to go when I get out. At least.
What's the story with your son's mother?
She has a new boyfriend, and she's having a kid with him, and she's never really been like, she's never had him really. My whole year in Cuyahoga, my son was with my mother and my sister.
Okay. So she's irresponsible, it sounds like.
Not completely, but yeah, she's only a mother on the holidays.
She got more interest in doing other things than taking care of her 4-year-old, right?
Yes.
Okay, that's what I mean by irresponsible.
Yeah.
Okay. And so far in your young life, you've been irresponsible too.
Yes.
You have a flash of responsibility by getting a job and doing the job. Other than that, you've been pretty irresponsible. And marred with making stupid decisions, probably because of drugs and alcohol and your environment. So what kind of drugs you do?
None specifically. I've done a lot of them, but
What have you done?
I've done methamphetamines, crack cocaine, marijuana, alcohol, obviously, opiates, smoke K2. That's really it.
All right. Anything else you want to say?
No, sir.
Okay, Ms. Himmeline.
Thank you, Your Honor. As the court's aware, the defendant has a lengthy and serious criminal history. He has nearly half a dozen juvenile adjudications, many of which involving weapons and offenses of violence, and that behavior has continued into the defendant's adulthood. He continues to carry weapons and commit acts of violence. This particular offense did put the community at risk. He was driving 102 miles per hour when he was pulled over, admittedly intoxicated and without a driver's license. And he did not take responsibility for this firearm when the police recovered it. He denied that it was his book bag. He denied it was his firearm.
Why did you do that?
Because the person, one of my coworkers, was gonna take up for it, but the cops, I guess, scared him into not doing it.
What do you mean take up for it?
Because he was allowed to carry, so he was gonna take out for say the gun was his, but I feel like the cops knew it was mine. Well, they knew it was mine because my wallet was in the book bag.
Right. So whose was it?
It was mine.
Okay, so why'd you try to bullshit him?
Because he was gonna take up for it. So
All right.
when they were saying that it was mine, I thought they were just trying to get me on it and didn't know.
Okay. Go ahead, Ms. Himmeline.
So, yes, Your Honor, he did not take responsibility for the firearm, did not submit to DNA without a search warrant, So for all of those reasons, the state is asking that the court impose a prison sentence in this case. Thank you.
Thank you. How far did you go through school?
Ninth grade.
Where'd you go?
I think I finished my ninth grade credits in a place called George Junior Republic in PA.
How'd you get there?
Ashtabula. I was in Ashtabula custody, county's custody, and when my mother had lost rights to us, I was put in a group home, but I ran from there, so they sent me to a lockdown residential.
Where'd you go before that?
Carrington on the east side of Cleveland on Nova Road. It's like a residential home.
All right. How well are your reading skills?
Great.
Huh?
Great.
How'd you learn to read if you only went to school kind of half-assed through ninth grade?
Well, they teach you how to read in like third grade.
Well, I know, but there's a lot of third graders running around that don't know how to read. There's a lot of fifth graders running around that don't know how to read. Just because they move you through school doesn't mean you're learning anything.
I've had a lot of time to read books.
What kind of books you read?
All types.
What kind? Give me an idea.
Like James Patterson, John Sanford, Stephen King.
Stephen King's a weirdo. That's just a matter of personal taste, but whatever. You ever read any history books?
Not really. I could think of.
All right. I've reviewed the pre-sentence report. And the letter you had sent me back in May. Listen to you, listen to counsel. I've considered all the provisions in 29, 29, 11, 12, and 13. I'm going to place you on community control for 5 years. You're going to serve 180 days in jail with credit for 81. The last 30 days you're going to enter into and complete the jail treatment program. You're going to follow all recommendations. Then you're going to go to the program at NeoCap, complete that program and follow those recommendations. When you finish that, you're going to go to a sober living facility for a minimum of 6 months. You're going to get a mental health evaluation. You're going to follow all those recommendations. You're to have no drugs or alcohol, and you'll be screened. You're to go to only one doctor and one dentist and one pharmacy for any prescription medication. You're to take any medication you are prescribed only as prescribed. You're going to sign releases so probation can get your records. You're going to get your GED. You're going to obtain and maintain full employment. Going to get a valid driver's license. Going to attend at least 3 AA or NA meetings a week and get a sponsor, and you're going to pay the costs and supervision fees. Anything else, Mr. Tompkins?
I don't believe so, Your Honor. Oh, you know what? Probably clear the warrant in Barberton.
What's the warrant for?
You have a warrant, Barberton. Do you know what it's for?
Do you know, Dave?
Is it a
Just
traffic
failing
ticket?
to appear.
Yeah, that's when they took my truck when I was driving with my temporary permit.
All right, so clear all warrants. You understand the terms?
So I have 3 more months in the detention center,
Right.
and then I go to NeoCat,
Right?
and then
So, I'll talk to you.
Then a sober living facility.
okay.
And a mental health evaluation. Any other questions?
No.
All right. Well, listen, if you violate, the state will file a motion to terminate. If I find you violated, then you'll go to prison for 36 months.
Okay.
So, I don't know if I'm right or if I'm wrong. I think everybody thinks I'm wrong. But we'll find out, because if you want the help's available. But whether you take advantage of it is completely up to you. And then you got to clear up the Cuyahoga case too.
Will I be able to do that while I'm in the detention center?
And they could try to borrow you.
I'll be able to write a motion of availability.
I think that's, I don't think that applies here. You would know better than me, Bill, but maybe you can talk to his PD down there to see if they want to borrow him, but I want him back here for that JTP, so I don't want him to disappear in the vast hole that is Cuyahoga County sometimes.
Understood, Your Honor. I think statutorily the notice of availability may not apply, but I can reach out to his public defender in Cuyahoga County, Your Honor.
Is it somebody in the public defender's office or just appointed counsel? Do you know?
I believe it's a public defender.
Do you know his name?
No.
I can look it up
All
on
right.
the docket, Your Honor.
The remaining charges are dismissed. Anything else, Ms. Himmelay?
No, Your Honor, thank you.
Mr. Watson?
Nothing further, Your Honor.
All right.
All rise.
You got the regular lifetime. You may not think about it, but you did. See what
Well, you got to say this. There is no more plain-spoken judge than that one, whether you agree or disagree with what he says. Good morning once again, everybody. It is TCF Live, episode number 329 today. Happy Thursday to all of you. A couple things to go through, and then we will get back to court. First, this is a good lead into tonight's sidebar right here on this channel, 8 p.m. Eastern, 5 Pacific, because we're going to talk about young people kind of going and doing bad things, and we're basing it off of 2 other cases that were actually from Judge O'Donnell's court. And here's yet a third one that we could roll into it too, where we've got these really young people making really stupid decisions. So do join us for that tonight. Again, sidebar, 8 p.m. East, 5 Pacific. I also want to acknowledge Barbara's $10 super chat while we were listening there, wishing my parents a happy 71st rather, wedding anniversary. That's amazing that Barbara's parents have been married for 71 years, so congrats to them. All right, I want to make you guys aware of something that we are releasing right now, right this very moment here at TCF. And let's get that pulled up on your screen right now. To make you guys aware of something that we are releasing right now, right this very moment at TCF. But we are going to mute it. This, my friends, is TCF Court Watch. One of the things that I have as a goal for this channel is for you guys to be able to get more than what you're going to get from anybody else in this space. So, and that's no shade to anybody else. Like Lone Wolf, you're in the chat right now. What you do is great. But what I'm trying to do is just provide more information, more entertainment, more, I guess is the best way to put it. So you can find this at tcfcourtwatch.com. Barbara just dropped a link for it. When you watch at tcfcourtwatch.com, you have the YouTube feed, you have the chat, but you get additional information. You get all of the courts that I'm currently looking at, up to my top 5, and those will be displayed in the top right corner there. We also do polls and court calls, stuff like that. That will appear in that box when those are available. Underneath the feed will be court notes. When there are specific things and information we have about a case that we're watching, we'll pop that in there. One of my favorite features, save this moment down at the bottom right, because I know a lot of you watch while you're working or you want to go back and check something out. If you need to step away, if you want to come back to something later, you simply put in your email. You can put in a note if you want and hit that save moment button. At the end of the show, you will automatically get an email with a link for you to pick up right where you left off. And you can do that one time. You can do it 100 times during the show. It doesn't matter. Mark as many moments as you want, and those will be emailed to you at the end of the show. At the very top, we have the judge bio. If you click on that, you will get a bio for the judge that we're currently watching. There is a glossary feature where we pulled over 200 legal terms straight from what we've been watching the last 8 weeks or so here at TCF. And it's all cross-referenced. It's all put out there in plain English. So if you have a legal term that you don't completely understand, pull up the glossary, type it in. Odds are it's in there. If it's not in there, the system will automatically tell me that it's not in there so I can add it to the glossary later on. This is just the beginning of what we will offer for Court Watch, but it's definitely an enhanced way for you to watch. It works great on desktop. It's also available on mobile. It looks a little bit different on mobile, but it works the same. I encourage all of you, the first thing you do, go and hit that FAQ button at the top right. It fully explains everything. If you've got other questions, just put it in the chat. But again, launching to everybody. We've been testing it with a select few the last few days, but you all have access now, tcfcourtwatch.com. A different way, a more enhanced way for you to enjoy your court in the morning. Alrighty, with all that having been said, let's go say good morning to Judge Oakley.
Your Honor, we would, I don't think there was no warrant was issued. It's like the show cause, I think it was a very recent one. So, we're waiting for Randy Raymond, Sam Mute, that's when they're pleading not guilty. We have reached a resolution in this matter.
Good.
So, Your Honor, on the A case, my client's going to be tendering a guilty plea to reduced charge of no operator's license on person, failed to display valid license. In addition, the people have agreed that the fee ticket, which had been put into a default back on June 24th, they're not in opposition to having that matter set aside for the grant.
I already did it. Set aside and dismissed.
That's the extent of our agreement.
Okay. All right. Mr. Horton, have you discussed your rights and options with counsel? Understand all those? Understand the possible penalty for the added charge? Up to 90 days in jail, up to $500 fines plus court costs? Okay. Yep. Understanding all of that, are you pleading guilty to that charge today? Doing so freely and voluntarily? If you're looking for that one. Just need a plea agreement for it. All right. Did you, on April 10, 2026, drive a vehicle in Van Buren Township while your license was suspended, revoked, or denied? I'll accept your plea to the added charge, dismiss both those original charges in keeping with your agreement.
Thank you.
What's the status of the license now?
36 district is the last hurdle I believe to clear. And
Good.
The balance. So he understands that the failed to display no ops could have a 30-day, additional period of penalty box. About what he's looking at to get everything spread out financially at 36.
Okay. So probably sometime first part of August, you'll have a license.
How long do you think it's going to take to get all your stuff squared out downtown?
How soon? When do you think you'll be driving legally? Best guess.
Okay. Next year.
Okay. All right. How much you owe downtown? What's it? Heather, what's in, I can never remember that name, the name of that program they're doing down to 36 to help you with the license start, fresh start, clean slate.
No,
That's ours.
That's it.
There's something they're doing at 36 though, isn't there? I thought they had a special program though.
That's a great font. So there's a process to help people navigate getting driver's license back, similar to
Okay.
what we have here.
Okay.
But they may have something where it's, I don't want, sometime annually, usually they'll offer.
Amnesties,
An amnesty, but I.
at least waive late fees. Yeah, all right. So are you working? Where do you work?
I be working before, so.
Who do you work for?
The
Who?
that.
What do they do? Okay, all right, full-time job? How long you been there? Good, all right. Okay, anything else you want me to consider before I sentence you? Okay. All right, so on this file, I've got the show cause fee, so that brings you up to $550 fines and costs. We'll work with you on payments. There's other options. You can talk about all the options downstairs before you get out of the building. Just make a plan, so when you leave here, you got a plan on how we're gonna take care of that. Yeah, for the one misdemeanor that I can put you in jail for 3 months, that one. Yeah. In lieu of jail time, I'm ordering 4 days on the court work program. We're currently running that program 7 days a week. That just happened. We just went to Sundays. So you pick which 4 days you want to work. The days you pick, you got to be here at 8 o'clock in the morning. You understand how that works? Do whatever the crew's doing that day. You might be cleaning up on the side of the road. Right, right, right.
Done here before, you don't have to find anywhere to go do that, we'll schedule. Tell you what's happening to show up for, so you're not running around getting signatures, so you just done through here.
Okay, so when I do that on the weekend?
Yeah, we're 7 days a week. You pick the days. I'm gonna warn you though, if you schedule weekends and then you miss a day, you don't get weekend schedules anymore. Because everybody wants weekends, so you get one shot at the weekend. Understood?
Go toward about 5.
No, it's in lieu of jail. Instead of putting you in jail, I'm ordering 4 days on the work program and $550 fines and costs. All right, any questions?
6 district, one of the, like, they ran out from March 9th to April 2nd, this year was their big push, so.
Yeah.
They
Yeah.
do it still, just, that's the window.
Missed the timing. All right, good luck on your license downtown.
Have a good day.
Are you Reyes too,
Yes,
David? Mr. Reyes, come on up. Go ahead.
Thank you. Josh Ed, we can get it with me, David Reyes, thanks for bringing the pre-trial. Mr. Reyes will be placing his name on the record as he approaches. Please take your name. David Reyes. Your rule waiver form ready to ring and stand mute. We have reached a resolution this matter. My client will be pleading guilty to a reduced charge of no operator's license on first. The 2-point offense driving while license suspended would be dismissed.
All right. Mr. Reyes, am I saying that right, Reyes?
Yeah.
Did you discuss your rights and options with Mr. Hadley?
Yeah.
You understand those rights and the options they give you?
Yeah.
Understand the possible penalty for the added charge?
Yeah.
Understanding all of that, are you pleading guilty to that charge freely and voluntarily today? May 12, 2026, at the airport, did you drive a vehicle that, when your license was suspended, revoked, or denied?
Yeah.
Satisfied, Mr. Hadley?
Yeah.
So am I. I'll dismiss the original charge. What should I know about Mr. Reyes?
Your Honor, Mr. Reyes, not too far off as well in being able to get the license back. So this isn't a matter of like a revoked license suspension. So I think he's got kind of a blueprint from him and what needs to get done. He does have an active payment plan at the court here as well. So we would just ask the court with assessing the fines, just to allow him to do all single payments.
It's active but late. Did you make a payment for June 22nd?
I think.
When did you make it? Did you make it after the 29th? All right, because my paperwork's dated the 29th and we've got no payment in June. All right, can you get on track today if you didn't make it? All right, and are you working? Who do you work for? How long have you been employed there?
Been there about 4 years.
Okay, what do they do?
Plastic gas tanks.
Okay, okay. All right, where are they located? I never heard of them.
Going here, River Drive.
Where at? Here on,
River Drive.
yeah, how far out?
Right up the freeway.
Okay.
Rolls.
Oh, okay, yeah, I know Bros. They're on that same little service drive? Yeah. Okay, all right.
I was looking at the payment schedule, not a payment invoice. My apologies.
No problem. No problem. Yeah, so currently we're showing a balance of 459 on the matters from 25. Today's ticket, today's file.
It's like you're in this one.
Okay.
No, two.
Yeah, just get back on track. Yep, get back on track. All right, so today's file, fines and costs are $500 and 4 days on the court work program. Did you hear me explain the work program a minute ago?
Yeah.
It's an alternative to jail time. You pick the days. All right. So as to the money, just roll that into your payment plan and go down and do that and schedule your work days. Any questions?
You said that was 504 days?
Work program. Yep. Yep. Got it? Good luck. Enjoy your day. John Lagman. Good morning, counsel. Lagman, Lagman.
Good morning, Your Honor. Since you went to 649 and so, you have Mr. Glad, who's approached you from my slab, they call it a condenser, third, Malachi.
Thank you.
Your Honor, there's a copy. I had it in the pre-trial case of the city attorney, therefore I understood since the original comments were saying Mr. Lax, he responsible for that account of double parking. Your Honor, with agreed upon fines of cost of $400, he's been advised that the rights he wishes to know.
All right. Mr. Lagman, that correct? You understand your rights and options? And is that your agreement? $400 for double parking? Dismiss the original charges? Can you pay that today, sir? Calendar there. Tell me when.
Maybe in a month.
All right. How about by August 7th?
Then I will bring a list.
All right. Well, understand that these original charges, these original charges don't get dismissed until we get our money.
Yes.
Okay.
Do that by yourself. Yeah.
Okay. Have a good day.
Thank you. I appreciate it.
Alrighty, friends, TCF Live on a Thursday, episode 329 today. Let's head down to Florida. Wade Mercer, say good morning to him.
I'm the county judge in Jackson County. You're being represented today for today's purposes only by Mr. John McDaniel, Assistant Public Defender, standing next to you. Our today is Mr. Jake Mitchell. He's in the courtroom. Mr. Thames, you have a hold out of Okaloosa County. I'm looking at a copy of the warrant now. It's a violation of probation allegation against you. And the judge over there has set no bond on this. What that means, Mr. Thames, is you're going to be held until you can get to Okaloosa County. When you get over there, you'll go to another first appearance and that judge will address your status. But right now you have no bond on this VOP warrant. Mr. Thames, do you have any questions?
No, sir.
All right, Mr. Thames, wish you the best.
All right.
Mr. McDaniel, that's all I had on my list this morning was just that one case. Anything else from the public defender's office?
No, Your Honor.
Corporal, anything else from the jail?
No, Your Honor.
Mr. Mitchell?
Nothing from the state.
We have Mr. Clemens on a VOP deal, violation of probation felony court conflict case that I'm on. And I believe we're expecting Miss Kelly to connect to this Zoom room.
Yes, I told her to connect to the jail Zoom link.
So thank you, fellas, very much. But we're just going to sit tight on this Zoom link for a couple of minutes because I think she should be connecting. And I know y'all have felony court perhaps later this morning.
Yeah, in the next 25 minutes.
Your Honor?
Yes, sir. Yes, sir.
I believe they took Mr. Clemens to the courthouse.
They are, but Miss Kelly's connecting to this Zoom link. Mr. Clemens is here, but his attorney's connecting to this Zoom room. So we got to.
Okay.
So as soon as she connects, we'll get that case, see where it stands. Okay.
Not a problem. Yes.
Thank you. We'll see y'all tomorrow.
Well, that was short and sweet. Alrighty, let's go back to Judge O'Donnell, new contestant there.
Motion for intervention. All right, Ms. Sparks, how old are you?
26.
How far did you go through school?
High school.
Should we stand?
No, you can remain seated. Are you a U.S. citizen?
Yes.
Are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yes.
What have you taken?
I've taken Lexapro, estradiol, and progesterone.
And that's all prescribed, is that all mental health meds or is it a mixture of medical and mental health?
A mixture of medical and mental health.
Okay. When's the last time you took any of the medication?
I took 2 last night, which was the Lexapro and progesterone at 8 p.m. And I took the estradiol this morning around 8 a.m.
Okay. Does it affect your ability to understand what's going on here so far?
No, sir.
All right. Did you get a copy of the indictment in this case?
Your Honor, we did proceed by information.
Information, okay, I'm sorry. Did you get a copy of the information? Do you have the waiver of...
We do, Your Honor.
All right. Did you get a copy of that information that was filed?
Yes, sir.
All right. Any questions about it?
No, sir.
Do you understand you have a right to have the case presented to the grand jury for them to decide whether or not to indict you?
Yes, sir.
Did you discuss that right with your attorney?
Yes, sir.
And are you going to waive that right?
No, sir. Yes, I'm sorry.
Okay, then she can sign the waiver.
Your Honor, I witnessed the defendant and her counsel sign the waiver of indictment. I signed it myself, and I'm now returning that to the court.
Thank you. All right, I'll accept the waiver of indictment. All right, now before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you some questions. If you don't understand a question, let me know that. If you want to speak to Mr. Hoflick a little bit more, let me know that. I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
No, sir.
Yeah, you're waiving those rights.
Yes, I am.
I'm going to go through all the rights that you would have, okay?
That I'm going to be waiving, okay.
And then ask you if you understand, then ask if you're going to waive them, okay?
Okay.
All right. If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After those witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes.
Do you understand that by pleading guilty to this felony, if you are convicted, then you are voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes.
Aggravated possession of drugs is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
If you are convicted of this offense, you may get a driver's license suspension of between 6 months and 5 years. Do you understand that?
Yes, sir.
And a conviction would prevent you from owning or possessing a firearm. Do you understand that?
Yes, sir.
If you are convicted of this offense and then are sentenced to prison, then as part of your sentence, you may have to serve a period of post-release control for up to 2 years under the parole authority. Do you understand that?
Yes, sir.
If you are placed on post-release control and you violate any conditions, the parole authority could send you back to prison for up to 9 months for each of your violations, up to 1/2 of the sentence. Do you understand that?
Yes, sir.
If that violation of post-release control is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under your post-release control. Do you understand that?
Yes, sir.
Do you understand that if you are sentenced to prison, you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violated any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, sir.
Now, has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
If you are sentenced, has anybody promised you what I would sentence you to?
No, sir.
Do you understand if you are sentenced, I do not have to follow any recommendation by either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with your lawyer before pleading guilty today?
Yes, sir.
Has he discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice he has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions?
No, sir.
All right, Ms. Tuttle, if this case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the facts would have shown that on the 20th of September 2025, in Willoughby Lake County, Ohio, the defendant was a passenger in a motor vehicle that was stopped in downtown Willoughby. She and her co-defendant were smoking marijuana inside of that vehicle. An officer approached and performed a probable cause search of that motor vehicle and located psilocybin in an amount less than bulk.
All right, Mr. Hoflick, anything to add to those facts?
No, Your Honor.
Ms. Sparks, did you hear what Ms. Tuttle said the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
What is your plea to aggravated possession of drugs, a felony of the 5th degree?
Guilty.
All right, Mr. Hoflick?
So this is a copy of this that we went over already. And it's the 9th signature.
And I witnessed the defendant and her counsel sign the written plea of guilty. I signed that as well. And I'm returning to the document to the court.
All right. All right, Ms. Sparks, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
All right, I'll accept the written plea of guilty. Defendant was present with counsel, advised of all of her rights, made a knowing, intelligent, and voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty to aggravated possession of drugs, a felony of the 5th degree. I will stay the criminal proceedings at this point, and I'll place you on a 2-year intervention plan. You're to have no illicit drugs or alcohol, and you'll be screened. I want you to continue your mental health treatment with LifeStance Health and follow all recommendations. I want you to get a drug and alcohol evaluation. And to follow all those recommendations. Now, your drug of choice in the past has been what? Marijuana?
Yes, sir.
What else?
Just marijuana.
Okay. Weren't there some, were there mushrooms involved here at some point?
Yes, Your Honor.
Okay, what
Yeah.
about those?
That was just like a one-time thing.
All right. How long have you been smoking marijuana?
Since I was about 16 years old.
All right. Now, I know that upon your referral and then when the report was completed, you tested positive.
Yes.
When's the last time you smoked it?
In April.
All right. So get this evaluation, be honest with the evaluators, and follow whatever the recommendations are.
Yes, sir.
How many different doctors do you go to?
3.
Including the Life Stance folks? Are they the prescribers on your mental health medication?
No. She only have an opinion on if she recommended for it to be adjusted or not. My providers at university hospitals
Okay.
have say over that.
All right, you're to see only the doctors you currently see, those 3 doctors. You see only 1 dentist, and you're to go to only 1 pharmacy for medication that is prescribed to you. You're to take your medication only as it's prescribed. And you're going to sign releases so probation can get all your records. Where do you work right now?
I work at the Neurotech.
What do you do there?
I'm a lab technician.
How long you been there?
4.5 years.
How much do you work?
7 days a week.
You're to maintain full employment?
Yes.
And what's the story on your driver's license?
They're valid as of today, but I've had
Why was it suspended?
traffic issues, speeding.
Okay, but it's valid now?
Yes.
All right, so make sure it's valid because that's one of the conditions. You maintain a valid driver's license.
Yes, sir.
And you're going to pay the costs and supervision fees. What was with this offense you picked up after this thing in Painesville? April.
I had a loaded firearm in the vehicle.
All right. And where were you? This was reduced from a felony. Why was it reduced? Do you know?
Because the weapon was forfeited, I believe.
Okay. You're on probation in Painesville Municipal Court?
Yes, sir.
What are they having you do there?
Like take drug tests.
All right. Ms. Knaus, any other terms you think are applicable?
No, thank you, Your Honor.
Do you understand all the terms?
Yes, Your Honor.
Any question about the terms?
No, Your Honor.
All right. If you violate the terms of your intervention plan, the state will file a motion to terminate the plan, and if I find you violated and I terminate it, then you stand convicted of this drug charge, correct? You understand that?
Yes, Your Honor.
That's probably, is that going to interfere with your job if that happens?
Yes, Your Honor.
All right, a lot at stake, right?
Yes, sir.
Okay. So you're getting a shot to straighten things out. Seems like with the long-term marijuana use, perhaps you have straightened that out. But that's going to be up to you. Anything else, Ms. Tuttle?
We'd ask the court to order the forfeiture of contraband and instrumentalities.
And the items subject to forfeiture are forfeited. Mr. Hoflick?
Yeah, thank you, Your Honor. No objection.
All right. So hopefully, Ms. Sparks, I won't see you again. So good luck to you.
Thank you, Your Honor.
All rise.
Entering hour number 2 now of TCF Live on this fine Thursday. Do me a favor if you haven't already, if you would be so kind, smash that like button, gently caress it. Whatever relationship you have with your personal like button, please execute that. Especially on a live show, it goes a long way to suggesting to YouTube that they put this in front of more people. So if you enjoy what you see, that is a no-cost way to help us out, so we'd very much appreciate that. Let's go to Otsego County, Michigan. Judge Hunter, Otsego County, of course, being where justice is best served in a converted pole barn.
Skull. Thank you, Mr. Skull. Welcome back here, James Thomas Skull. Yes. Have you had enough time to stay in contact with your attorney since you got appointed an attorney?
Yes, sir.
All right. Mr. Brown, how should we be proceeding for this probation violation hearing?
I could have just one moment to pull this up, Your Honor. We are going to have a plea.
All right, and the nature of the plea? There was one non-technical violation alleging termination from the drug court program due to the violations. There's usually a plea is charged.
Okay, it is. If there's just one count, it is charged, Your Honor. I did discuss that.
Is that your intention, Mr. Gall?
Yes, Your
And
Honor.
I know you intended that before. I decided not to allow you to enter a plea until you got a chance to talk with your attorney. Have you had a chance to talk with your attorney?
Yes, sir.
Is that how you want to proceed?
Yes, sir.
Raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, sir.
You understand that if you're convicted of violating the non-technical violation of being unsuccessfully terminated from drug court, that is a non-technical probation violation?
Yes, sir.
Meaning, non-technical just means that you're then punishable by up to the maximum that you're on probation for. So you're on probation until July 3rd. That's a 5-year maximum by statute. Are you aware of that?
Yes, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
Has anyone promised you anything to get you to plead guilty?
No, sir.
Has anyone threatened you?
No, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
You were given the opportunity at drug court as a component of your sentence, correct?
Yes, sir.
And that was not only a component of your sentence, it was a requirement that you successfully complete drug court. Is that right?
Yes, sir.
And did you have violations while you were in drug court?
Yes, sir.
Did the number of and type of violations lead to ultimately you being unsuccessfully discharged?
Yes, sir.
And you understand that as a component and requirement of your probation, right?
Yes, sir.
Counsel, is there an adequate factual basis?
It was asked, I think, Judge. Yes, Your Honor.
The attorneys believe the court is compliant with the court order to take pleas.
Yes, Your Honor. Yes, Your Honor.
Are either one of the attorneys aware of any promises, threats, or inducements not disclosed?
I'm by the people, thank you. I'm by the fence.
I accept your plea, Mr. Galt. I find that you freely, knowingly, and voluntarily given that it's clear that there is a factual basis for your plea. So I'll accept that and enter it on your record. Meet with probation staff before you leave today. They'll set up an interview time and they're going to prepare a full, what's called a pre-sentence investigative report. Tell me more about what happened while you're in drug court, what happened in terms of this offense and otherwise about you. Then I'll have a sentencing hearing that would be somewhere around the nature of 30 days from now. You'll get a separate notice in the mail, and that sentencing hearing will be just like we all are today in person. Any questions? No, sir. All right, for probation before you.
Okay, thank you.
Before we recess until Mr. Lacy is brought up.
All right.
Alrighty, short and sweet interaction there with Judge Hunter. Let's go to Louisiana. Looks like the board is getting started up. We'll check in with them.
Turn the camera on.
Turn the camera on, please.
Thank you. Let me see.
Okay. Mr. Craig, could you state your name and DLC number for the record? Okay, you're on mute.
You can hear me?
Yes, sir.
Okay,
Okay, state your name and DLC number for the record.
James Robert Craig III, DOC number 373446.
Okay, Mr. Craig, you're here today for a revocation hearing. Do you have your parole questionnaire with you?
Yes, sir.
Okay, I'm gonna let that, okay, did, you sign that questionnaire?
Yes, sir.
Do you realize you're not eligible for appointed counsel? If you wanted counsel, you would have to hire counsel.
Yes, sir.
Okay, you want to proceed today?
Yes, sir.
Okay, can that fella, that's with you, could he introduce himself, please?
I want you to introduce yourself.
Yes, I'm Lieutenant Ford, Franklin Parish Detention Center.
Okay, Lieutenant, I see he's been there probably about 8 months. Do, y'all have any problems with him?
I have no information on this gentleman. It's kind of like my first, second time actually
I just want
meeting him. So
okay, all right.
Okay.
Thank you. You can give it back to Mr. Craig. Okay, Mr. Craig, today, you have no one in support, and we do have the P&P officer on the line. The Hinton will get to you at the proper time.
Okay, your case has been assigned to Ms. Renatza. Ms. Renatza?
Thank you. Good morning, Mr. Craig.
Good morning.
Mr. Craig, I'm going to read the allegations against you, and then you'll enter a plea of guilty or not guilty, and then we'll talk about it, okay?
Yes, ma'am.
So the first allegation is that you violated condition number 4, and it reads, you were arrested September 26, 2025 by probation and parole on a no bond felony warrant in Franklin Parish for the offenses of criminal trespass and burglary. You pled guilty February 24th of 26 to the amended offense of theft, and you were sentenced to 6 months in the parish jail. You also pled guilty to the amended offense of criminal trespass, and you were sentenced to serve 6 months to run consecutive with the previous docket. So how do you plead to violating condition number 4?
I plead guilty, ma'am. Guilty.
You plead guilty. And the next one has to do with your fees. Condition number 10 says you're currently behind $630 toward your supervision fees. So how do you plead to that one?
I wasn't that much. I plead guilty to it, but it raised up while I've been locked up.
Yeah, okay. So I noticed in your preliminary hearing, you pled not guilty to violating to the criminal activity.
Yes, ma'am.
And so today you're pleading guilty?
I'll take responsibility for my actions.
Okay.
So, yes, ma'am.
So tell us what happened. I mean, why'd you do what you did?
No, honestly, I lived at the address at Birch Road. I lived there for 2 years, and only thing I did was I went back over there and because I was living in a tent, which Mr. Hilton knows. I was living in a tent. Only thing I did was went back over there and got my charcoal from over there to barbecue with. While I was living in a tent, I plead guilty to going back over the trespass and all that there, but misdemeanor. I plead guilty to a misdemeanor offense for the the charcoal.
Well, it seems like there's a lot more missing. Let's just hear from Mr. Hinton. Mr. Hinton, what can you tell us about what happened?
Good morning. Yes, ma'am. I believe it was more than just charcoal, from what I understand, because he was ordered to pay restitution to the victim in the amount of $940 on both cases, both counts he pled to.
Yes.
The Franklin Parish Sheriff's Office contacted me when they obtained their warrants. They had him on camera going into some buildings on the property that he used to live at but no longer resided at. And he also took some things off the porch. We only went and arrested him when Franklin Parish asked us to pick him up. At that point, because he was living in Monroe at the time, so we were able to arrest him at his residence and take him to Franklin Parish for his prosecution. Other than that, I really, Mr. Craig was not a hard case to supervise. He reported, I was able to find him. He just wasn't paying his fees, and he was having trouble getting enough money to maintain himself. But the arrest and the fact that he's on a violent offense has led to where we're at today.
Did he swing you?
I'm sorry, sir.
Okay, was there any resisting upon the arrest? It was simple.
No, sir. When we made entry into the house, we didn't have any issues with him. He came to the door. He went into handcuffs easily.
Okay.
And we didn't have any resistance from anybody in the house either.
Okay, thank you. I'm sorry, Mr. Knotts, for interrupting.
No, that's okay. So, Mr. Craig, according to the information that I'm looking at, it says you were seen on the video footage entering and removing items from the property. You stole a large number of tools from the shed.
That's what I'm saying. I don't know about no tools. And even in the police report, he says that he don't know when the stuff came out stolen. Only thing they had me on video is going in the side-by-side icebox where when I lived there, I kept my tools. And I opened it up. The camera's right there. I opened it up. Nothing was in it. I closed it back. And I got the charcoal and I left. That's the only thing I left with.
Mm-hmm. Well, so your restitution is a total of $900?
I think I went to court in February. That sounds about right.
Okay. All right, Mr. Freeman, I don't have any other questions.
I have no questions. Just note for the record that he expires in 5 months.
Mr. Crater?
No questions from me.
All right, Mr. Craig,
Can I speak real quick
what would you like us to know?
I understand, which, Mr. Hinton knows too, I was in, online college, University of Phoenix for, social business. And I was on the dean's list also. If you could look at all my records, I never stayed out longer than 3 months. I stayed out 2.5 years this time. And I was doing real good. I have a fiancee that was keeping me out of trouble. I just made a bad choice this time here, going back over there.
Yeah, well, you did. I'm gonna tell you, Mr. Craig, you are a fourth offender, like you said. I mean, I've looked at your record. You are on supervision for a very violent offense. Today, my vote is going to be to revoke your parole, because I think even though you pled guilty to a misdemeanor, I find you violated condition number 4.
Okay, Mr. Prater.
I concur.
Okay, Mr. Craig, I also concur. Like I say, you have 5 months remaining on your sentence, so they'll recalculate your time and let you know. Good luck to you, sir.
Yes, sir. Thank you.
Good luck.
Well, the board doing what the board does. That was not a surprise to anybody, I don't think. Hour 2 of TCF Live. Let's go to Texas. We will say good morning to Judge Stevens.
Do something about our backlog. It's killing us here. You're Malachi? Yes. DeGitry? All right, in 26 CR 195, you're charged with the first-degree felony of aggravated assault. He says he was a member of your family as well, which increases a punishment range.
Was charged with nothing.
Yeah, well, it's still family anyway. This aggravated assault, which would have been a second-degree felony, is actually indicted as a first-degree felony because when you assault a family member, that increases the exposure to responsibility for a crime. And the theory there is, if you're going to treat family members badly, what are you going to do to a person who's a stranger? That's the spirit behind that law. But anyway, you're looking at a first-degree felony. If convicted of this, you're looking at no less than 5 years imprisonment to life imprisonment. And because this is a firearm, a deadly weapon that was used, if you're convicted and sentenced to prison, you won't be parolable until you serve at least 50% of your time, which is a long time. What are we going to do today?
Judge, I've just got an updated offer for Mr. Coleman. He was just assigned the case. I'm hoping to talk to him about that, see if he's in trial next door.
Huh?
They're in trial next door. But
When's he going to start coming over here? Next week?
Yes.
He just had
to finish the trial. If
Um,
I could have one more 4-week reset to figure out what direction we're going, I need to be able to sit down and talk to Mr. Coleman.
This, in this case, Mr. Guidry, I don't know if this is a relative of yours, but under the law, whether it's blood relation or not, when you're accused of a crime like this, a serious felony offense, you cannot have any contact with that person. Do you understand? Yes. And if you are, your bond, if I find out about it, your bond will be revoked and you'll sit it out in the county jail until we can dispose of this case. if anyone on your behalf tries to contact this person, which I know happens too often because people get into trouble and then they start trying to figure out how to absolve themselves of trouble, and they do it the wrong way. The law states, and the rules of this court state, you cannot approach or have any contact with a victim, even if they're a relative. And it would even be a fact if it was your parent that you had shot. But a cousin, still, you cannot, and if I find out about it, because the state's always looking into that. They want to make sure that people are safe, because too often in this court, people think that they can manipulate the law. When they do that, they get in more trouble with me. If I find out you had any contact with this person or anyone on your behalf, it'll be this quick. You're going to jail until we can figure the resolvement of this, which could take years.
We've been over that a couple of times.
Yeah, I know. And the lawyers advise them, and still it happens over and over again. And those people are sitting in jail, waiting for trials for years sometimes. And that's what happens if you don't follow the rules. Is that clear?
Yes, sir.
And I'm going to ask the state to make sure, if you'd be so kind, check on the victim, make sure that there's been no contact.
Yes, sir.
Because the moment I want to know, a warrant will be for your arrest. That crystal clear. You're looking at life imprisonment, sir. Do you understand the importance of this? How old are you right now? Yeah. Life, that's the rest of your life. In a cell. Well, that's what happens when you shoot people. Usually relatives. If you're going to treat a relative like this, what are you going to do to a stranger who you take a disliking to? Well, there's surveillance footage of this. Did you get that?
I have the discovery.
You have it? Okay.
It's just a very serious offense and we're handling it, and
And I just want to make sure there was this, it looks like a video here that's out there that you certainly don't want to miss. What was the significance of the injury here?
He was shot in the chest. I'm not sure.
Really? I mean, that's lethal, isn't it? Generally.
Yes, sir.
Oh.
believe he had that.
I didn't hear what you're saying.
I believe he had one to his abdomen and an issue with his liver resulting from that.
The liver?
The liver.
That can be lethal.
That's why the serious.
Okay, and yeah, gunshot injuries to the liver and the stomach. I know people who've been shot in the stomach before. Try to digest your food for the rest of your life with that. Okay, next event.
Stretch Brandon Hospital.
Done.
Thank you.
You're still here?
Yes.
Zariah? Here.
Reagan Day. It is Reagan Day.
Well, hopefully Reagan can resolve some stuff today.
Loads of a lot of initiatives today.
That means,
It wants.
when we kick the can down the road day. 26 CR 833 is called. Can you pronounce your first name?
Zoe.
This is.
Zoe area.
Everybody's started once. What is it?
Zoe area.
Okay, Zoe area. Okay, I had never heard of that one before. Is it a family name? I mean, was it like an aunt or someone that you? Okay, where's it taken from? I knew your mom. God bless you. But I mean, how did she come up with that name? Because I've never heard of that one before. Where'd you come up with that? It's part of your name. I'll be. Yeah. That's unique. All right. All that aside, now serious stuff here. You're charged with theft, but see, the problem you have is that according to this indictment, you have 2 or more prior theft convictions. It looks like you had 3 convictions on one day, April 29th of 2022, out of the County Court at Law 3 of Jefferson County, Texas. When you have 2 or more theft convictions, if you steal a pack of gum, it's a felony for the rest of your life. I don't know what you're stealing, but it says personal, marked from Market Basket, and it was less than $2,500. If it was a penny, if it was worth a penny, it's a felony. I mean, that's important. You're supposed to live honestly. Thou shalt not steal. You know, that's in the commandments and all, and in the law. So but you went through these 3 cases, and certainly it was impressed upon you the importance. You had to go in front of a judge, and I don't know what happened on the disposition, but you were convicted of these. You may have paid a fine. I don't know, you might have even gone to jail, which is not what you want to do. But here, you're looking at up to 2 years in the state jail. And this is not a misdemeanor. This is a felony, which follows you, if convicted, the rest of your life. Try to get a job that you want when you've got a felony conviction. Good luck. People don't hire folks like that, especially if it's theft related. They go, well, if they're going to steal from others, why hire her? But before we know it, she'll steal all our stuff. That's what people think. That's why you have to live honestly. Okay. From here on, do that. Okay. All right. Oh, what are we going to do today?
Judge, this is an initial setting. I need to talk with her about the discovery and anything else if I can have a 4-week reset. I have received an offer. I just have not had this is my first encounter with her, so I need time to go through everything with her.
Don't steal. Again, a penny of something worth a penny is still a felony for you for the rest of your life. That ought to help you be honest and do the right thing. No one, trust me, you don't want to go to prison. And that's where this goes. It's a prison type facility. Fix this. Live honestly. Get a resetting. Darryl Jones.
Wait, come here.
That's you. Where's Darryl Jones?
Trying to make his way up here.
Come on, yeah, whatever way you can get here.
I'm sorry.
Okay. In 26 CR 638, you are Darryl Dwayne Jones, correct?
Yes, sir.
You're here with Ms. Minaldi, your attorney and the state's attorney. Probably intimately familiar with this indictment that's charging you with a 3rd-degree felony of tampering with physical evidence If convicted of a third-degree felony, you face no less than more than 10 years confinement in prison, and a fine up to $10,000 can be assessed.
See what that in there.
Says he's got a prior conviction, but it looks like it's a misdemeanor of drugs, illegal possession of controlled substance out of County Court of Law 2. I don't see another felony. Due to being a felon, possessing a bottle. Did you see this probably also? You always do. I'm not talking to you. I'm sorry. Yeah. Why are they talking about, what's this about in this? Are they just wrong? They must be wrong because they keep talking about him being a felon due to Jones leaving the scene of a firearm with intent to impair its as evidence and being a felon possessing a firearm at a location in which he does not live. He was charged with unlawful possession of a firearm by a felon and tampering. I guess that were they mistaken, you think?
Well, the system did show that it was felony.
You got a misdemeanor, right?
Yes.
Okay.
The end result was a felony was disposed of via misdemeanor plea. And that's what caused the confusion with the police. They always verify that before they actually charge the offense of unlawful possession of a firearm by a felon. The more serious matter is the fact that what he's charged with here, Judge.
Well, that's well and good, but I think it's a serious matter in a probable cause affidavit to make statements that aren't accurate.
At the time it was made, it was accurate.
He was a felon?
No,
their system showed that he was convicted of a felony offense of possession of
how does that happen? Was that misstatements put into the computer or something?
I think they didn't dig far enough into the system, Judge. I don't believe they made a false statement, Your Honor. It turns out to not be accurate, but I believe that what they were looking at gave them false information.
So that's my question is, why is that false information today?
From a lesser included plea is what my understanding is.
That's what it's showing, Judge. And I can,
system might register still as it being a felony. However, it was not resolved as a felony conviction. It was resolved as a lesser included misdemeanor conviction.
Mr. Jones was arrested on December 28, 2016 for the felony third-degree offense of possession of a controlled substance. That is what their system showed, is that he was convicted of that matter. When they dug a little further, it shows that on September 25th of 2017, it resulted in a 5-day confinement in Jefferson County Jail, which has to have been some misdemeanor disposition.
Well, the system is clearing up the fact that he doesn't have a prior conviction.
I would hope so too.
Because that's what they're relying on, is that data.
It's hard to make. So
Isn't a mistake I want to make. So you're looking at up to 10 years in prison. At the end of the day, that's still serious. What today?
Judge, it is an initial setting. I need time to go through his discovery with him and him to get in contact with my office. So if I could have 4 weeks to do.
You got it. Okay, Antonio Landry.
Tim gifts 5 memberships. Thank you, Tim. I very much appreciate that. You've been very generous in bringing in new members lately, so really do appreciate that so much. Also, a reminder and news for those of you who have come in recently. Today we launched TCF Court Watch, a more enhanced way for you to watch this show. You can use the link in the pinned chat or scan the QR code on your screen, but do check it out. It's the same feed you're getting from YouTube, the same chat, but some extras, so give it a look.
Looking at 4 different resettings already for the announcement document. You're charged with the third-degree felony of harassment on a public servant. What are we doing today?
Judge, I need one more full reset. He has got to come in and look at his videos and I
Said it. We're gonna no. We've been. No, hold on. Let's take it easy. All right. You have a drug patch too?
I put hands on my tongue.
You mumbled. I didn't hear what you just said. Sir?
Yeah, put hands on my tongue.
He should have a drug patch, judge of some kind, because when he was last in court, he tested positive for methamphetamine and cocaine on April 2nd. That being said,
I think that was
missed that because
I think we missed on that one. There should have been a drug patch, probably not a GPS. I don't know why that was. I'm sure you're mumbling. You have to.
I said they wanted to put the drug patch on, but you told them to put an ankle monitor on.
Yeah, I don't know why. Okay, tell me that again.
When I was wanted out, they said you put an ankle monitor. They was about to put the drug patch, but they said put an ankle monitor on the.
Yeah, that doesn't make any that I don't know why that happened.
I had one out there
because that's apples and oranges. You should have had a drug patch. That's what I've only done for 19 years and stuff like this.
That's
Something weird happened here.
We can get them switched out, Judge, if you want to switch.
No, we're gonna test him right now to make sure he's okay. I'm sorry, what do you say?
He's saying this.
Yeah, well, we're gonna still test you because you tested positive before. You want to make sure you're making the right choices. Okay, so we go from April 2nd to April 9th.
Yes.
An announcement there. To May 11th to May 14th. So that's been 4. Then June 1st. And then now today. So this is like this 5th announcement date. So what are we doing today?
Judge, this is the second day that we have approached on for an announcement.
No, I have 5 announcement settings here. Here, look out.
I believe
Don't. I want you to.
Sometimes I believe some of those we canceled docket and I had to reset them. I'm pretty sure. And it looks like the memo that was on April 2nd. I was unaware that you were in a seminar. And
5 times?
No, I said 2 times, I think. There were 2 different ones. It looks like the memo from April 2nd that was done.
He was indicted in November.
I understand. Judge.
Okay, and it's now 8 months have gone by, and what are we going to do today?
I need 3 weeks for him to look at his videos. I need him to come into the office and do that.
Right.
No, I'm telling you.
Reset it for 3 weeks and sit over there. I will give you this. Alejandro Sanchez. Right, these things.
And Tom thought that straight up actually.
Alejandro Sanchez, is that you? You're charged with stage F felony of looks like solicitation for prostitution, which carries with it up to 2 years in a state jail.
Yeah. It's harassment.
You're still living in Houston, Texas?
Yes.
Why were you here?
I was working. Well, I'm still working here at the Exxon.
Doing what? I'm sorry, scaffolding? What are you getting paid per hour on that?
Right now it's 25.
Are you retained?
No, Judge, he has filled out a new affidavit of indigency. It has not.
Yeah, you're going to pay for your lawyer.
It has not gone to Ellie
I mean,
yet.
you're making over $50,000. You're not indigent. Okay, we got to fix the taxpayers aren't going to pay for your situation when you're able to pay. Do you understand, sir? Okay, that's what we all have to do. Pay for our costs. You have costs. The taxpayers are doing it. That's not fair to them. So what do we need to do
I
about
guess
that?
got him on a designation docket in a
Now,
couple
what do
of
we
weeks.
need to do about transferring him out of indigency to getting him a new lawyer?
Judge, I think he has to have time to contact attorneys to retain one.
Yeah, I don't expect him
No,
to
they
pick up the
correct me
phone
if
right this
I
moment.
think that looks like putting him on a designation docket in a couple of weeks.
The designation, he'll do the
And then-
indigent form, we can deny Reagan on it, and remove her from the system. Then he can.
Yeah, you're gonna have to hire your own lawyer, and which is when we make a mess, we have to fix it ourselves, and that's being responsible. And the taxpayers aren't going to pay when you're able to pay. That's not fair to them. So you got 4 weeks. I'm gonna give you 4 weeks to talk to some lawyers about hiring them. You can even hire her. She does. She handles cases that aren't part of her indigency representation, but that would be between you and her. But you got 4 weeks, and you're going to get a resetting. Make sure that whoever you may hire, they know about that resetting that you're about to sign. Okay, reset 4 weeks. Thank you. Thank you. Bridget Webblev.
Judge, she
is what?
she had a new information filed on her to resolve the felony. This is one that we tried to do on Monday. It was gonna be a lesser included, but now it's just misdemeanors. I have to go down the hall and plead her misdemeanors. And then I'm under the impression that the felony is gonna be dismissed as a result of that.
Well, I don't know who the.
Tommy Coleman is the prosecutor.
Can we get Mr. Coleman in here
He's in trial next year, Judge.
right now?
Do you have
Do y'all know anything about this?
The possession in a correctional facility that Tommy was trying to plead down?
Yes, it's been filed down, Mr.
It's been
McCoy.
filed.
It's been filed. It's ready to go this morning, so.
Yeah, I'm gonna hop down there and do those, but the
Okay.
felony's being dismissed.
Yes, yeah,
Okay,
yeah.
so the felony would be a
So
dismissal.
this case, well, this case has been changed to a Class B misdemeanor.
That's correct.
Correct.
Okay, what felony are you talking about?
She did have a felony of possession of a substance in a.
In whose court is that?
It was in yours, Judge. We tried to handle it Monday.
It's right there. That's it.
Okay,
That's it.
it's this case.
It's this.
Right, right. We were doing it. We were doing a lesser included. That's why you wrote Class B on there. We were going to try to do a lesser, and it's not a lesser included, so we had to refile it down the hall. So we'll dismiss that as soon as they plead it down the hall.
All right, then let me, I need some whiteout
No,
because
she didn't. She stayed.
I changed this to
Couldn't because of the.
Right,
I
so.
changed this to a Class B misdemeanor, and it's not gonna be changed, it's going to be dismissed.
Yeah, they're trying to dismiss this.
And just let me know.
You put a nice.
I need a whiteout from anybody. Do you have one?
I do not, Judge. Oh.
Here you go, dude.
Look.
Come on, come on.
I'll take anybody's whiteout.
No.
Oh, you got the liquid kind.
Yeah, he likes liquid over.
Got a little left on your nose there, dude.
Yeah, killer.
Oh, I'm trying to do. Slowly. By the way, John Dixon's moving up really fast because it's for pro se on a cruise. No, you were gonna resolve him. I was not sure. No, you were the sitting person.
Thank you.
You had to, I'm saying part you are gonna do very fine.
Alrighty, friends, hour 2 of TCF Live. Well, they are between contestants. Let's move along. We might come back later. But let's go back to Judge O'Donnell for round 3 there this morning.
To read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No. Prior,
What's that?
when I was younger, but not any recently.
All right, did you get a copy of the information that was filed in this case?
Yes.
Any questions about it?
No.
You understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes.
Did you discuss that right with your attorney?
Yes.
And are you going to waive that right?
Yes.
The waiver I have is,
I've got one, Corey. You need one.
Oh my God, I think we have one in here as well.
oh, you know
Yeah,
one?
we had one.
Oh, it's, I have it. I'm sorry. I could take that back, Bob, too. Sorry about that. Okay. Sorry.
The defendant and her counsel signed the waiver of indictment. I signed it as well, and we're turning to.
Thank you. All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Hinton some more, let me know, and I'll give you more time. Do you understand that?
Yes.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a lawyer, one will be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, sir.
You understand by pleading guilty to this felony, if you are convicted, you are voluntarily giving up your freedom for whatever period of time. I could sentence you to prison, to jail, or community control.
Yes, sir.
Aggravated possession of drugs is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
If you are convicted of this offense, it may result in a driver's license suspension of between 6 months and 5 years. Do you understand that?
Yes, sir.
If you are convicted, then a conviction would prevent you from owning or possessing a firearm. Do you understand that?
Yes, sir.
If you are convicted on this case and sentenced to prison, and as part of your sentence, you may be placed on post-release control for up to 2 years after you're released from prison. Do you understand that?
Yes, sir.
Conditions will be placed upon you. If you violate the conditions, the parole authority could return you to prison for up to 6 months. Do you understand that?
Yes, sir.
If that violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
If you are convicted and sentenced to prison, you are eligible for judicial release. Do you understand that?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, sir.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I would sentence you to in this case?
No.
Do you understand I would not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes.
Have you had enough time to talk with Mr. Hinton before pleading guilty today?
Yes.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No, sir.
Ms. Tuttle, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the facts would have shown that on the 20th of September 2025 in the city of Willoughby, Lake County, Ohio, the defendant was in the driver's seat of a motor vehicle with her co-defendant in the passenger seat. They were parked in downtown Willoughby smoking marijuana inside of the vehicle. Officers approached and performed a probable cause search of that vehicle where they located psilocybin in an amount less than bulk. Thank you.
All right, Mr. Hinton, anything to add to those facts?
Sounds accurate, Your Honor.
Ms. Fernandez, did you hear what Ms. Tuttle said the facts would show if the case went to trial?
Yes, sir.
Are those facts true?
Yes, sir.
What is your plea to aggravated possession of drugs, a felony 5?
Not guilty. I mean, guilty. My bad.
Mr. Hinton?
Thank you, Your Honor. Sure.
Your Honor, I witnessed the defendant and her counsel sign the written plea of guilty. I've signed that as well, and I'm returning it to the law.
Ms. Fernandez, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes.
I accept the written plea of guilty. Defendant was present. Mr. Hinton advised of all of her rights, made a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequences of her guilty plea, and the maximum penalty. Found it to be knowing, intelligent, and voluntary. I will accept the plea of guilty to aggravated possession of drugs, a felony 5. I'll state in criminal proceedings and place you on a 2-year intervention plan. You're to serve 7 days in jail with credit for 7, no drugs or alcohol, with screens. You're going to complete the program you're involved in at Lake Geauga and follow all their recommendations. Attend at least 3 AA or NA meetings a week and obtain a sponsor. Maintain full employment. Get a valid driver's license. You're to see only 1 doctor and 1 dentist and 1 pharmacy for any prescription medication. If you are prescribed medication, take it only as prescribed. Sign releases so probation can get your records and pay the costs and supervision fees. Any other terms, Ms. Crook?
No, Your Honor.
Do you understand the terms?
Yes.
If you fail to abide by the terms, the state will file a motion to terminate your intervention plan. If I find you violated, then you'll be convicted of this felony. Do you understand that?
Yes, sir.
If you are convicted of a felony, what happens to your job?
I would lose my job.
Okay. How long have you been working there?
About 4.5 years, almost 5.
What do you do?
I'm quality assurance.
Okay. Can't do that when you're high, can you?
Right, yeah.
Okay. Why did you pick up another offense after this one in Willoughby?
Just the ignorance of going out and, thinking, not being aware of my situation.
Okay.
And
Not
drinking.
being smart.
Yeah.
Okay. All right. Whatever is subject to forfeiture is forfeited. Anything else, Ms. Tuttle?
No, thank you, Your Honor.
Mr. Hint?
Nothing further, Your Honor.
All right, straighten it out, Ms. Fernandez.
All right.
Alrighty, friends, TCF Live on a Thursday. Reminder to you that you can try out TCFCourtWatch.com, just released today to the public. A more enhanced way to watch the show. There's a link in the pinned chat, or you can scan the QR code on your screen. Give it a look. It's fun. It gives you more information than what you just get straight from YouTube. Anywho, let's do this. Haven't gone here in a while. Let's go to Kentucky. Judge Williams.
I did file a motion for a hearing regarding domestic violence.
I have
in the
never had
commission.
one of those. You know,
Well,
Mr. Stockton, what do you have to come around where I can see you here?
Well, I anticipated it probably be final, but my understanding is the court has to make a determination for the domestic violence, makes her eligible for shop probation based on the evidence. And I figured we'd set a hearing because I'll have to have the officer here and some witnesses here.
Okay, we're gonna set it for next month then.
yes, Judge.
Do you want to do it in the morning or afternoon?
Let's just do it at the end of the docket.
Okay.
That would be August the 6th.
Thank you, Judge.
No, I'm gonna go ahead and censor. The hearing will just be for, come back here.
Oh, I'm so sorry.
I'm gonna go ahead and censor and
Oh, I'm so sorry.
that just be a finding that's added. Isn't that right, Mr. Stockton?
That's the way I understand the statute, Your Honor, that
Yeah.
affects the judgment.
Because if I don't, she remains a county prisoner if I don't censor.
Right.
Well, plead guilty to manslaughter, first degree, the defendant shall receive a sentence of 15 years to serve. All evidence will be disposed of. This judgment, of course, is subject to a hearing, which will be, the sentencing will be supplemented by the findings of the hearing, which we have scheduled for August the 6th. Okay, thank you very much.
Thank you, Judge.
Yes. Sharla Brown. Sharla Brown. Commonwealth versus Sharla Brown, 25 CR 0087. Are you Sharla Brown?
Yes.
Good morning. You were born in 1984.
Yes.
That's support agent. We're here on a pretrial conference. What do you have? Judge, we have a misdemeanor plea for court to consider. The motion's been tendered that says you wish to enter a plea. Is that correct?
Yes.
We're currently under the influence of drugs or alcohol. This is plea free and voluntarily given.
Yes.
Are you the same person that we just identified a few minutes ago?
Yes.
Is your judgment impaired today? Have you discussed the charges with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
What?
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about your
Yes.
case? You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes.
I'm gonna go over them. At the end, I'll ask you if you understand. If you have any questions, step aside and ask your attorney. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial. The jury right to be represented counsel at your jury trial. You rather have to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. The right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to a higher court if you lose, and you have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand? But even if you're guilty, you give up all those rights. You understand that?
Yes.
I may consider Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll order a pre-sentence investigation. The list is going to be misdemeanors. You don't have to do pre-sentence. Step to the left. Ms. Gordon Anderson, what's the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, second degree, the defendant shall receive a sentence of 12 months, probated for 12 months. supervised. The defendant shall receive credit for time served. The defendant shall do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Yeah, why are we doing a misdemeanor? Please, she wasn't eligible for pretrial diversion.
May we approach, Your Honor?
That's okay, I understand. So, is this what you agreed to? Get behind the post. Okay. Are you pleading guilty to the amended counts because you are guilty as charged? You can say something, yes, no.
Yeah.
No, yes.
Yes.
Okay. You're doing so of your own free will, correct? And under constitutional rights, it's still your desire to give up those rights, and you're guilty for allow court to put your punishment in range for you to go off.
Yes.
You understand that? Okay. Is that your signature on the motion now?
Yes.
Yeah, I'll accept the agreement and the judgment today. Now, is she to be supervised under this probation?
Thank you. Yes.
Okay, you need to meet with the probation officer. What are the court costs?
$150.
$150. Need some time to pay that. I'll let you pay first payment 30 days from today and $30 every month you pay it, okay? Luther Connor. Humble versus, are you Luther Connor?
Yes.
Good morning. This is 26 CR 0001. Commonwealth Kentucky versus Luther Connor. Mr. Connor, were you born in 1977?
Yes.
Last 4 digits.
Yes.
5220. 5220.
Yeah.
Okay, what do we have here?
Judge, Luther has just made bond. He's been in for some time. My investigator is engaged in the case and work is ongoing. This is one that's likely headed for a trial. I couldn't say that we're ready for a trial just yet, because we still have some work to do on our end.
What's the charge?
Strangulation, so I would think we've asked this a couple of times to the investigator. I think the next month, we set a trial date.
You want to put on a negotiation day next month too?
Well, it may not be, but also won't be any work if it's not, so.
Yeah, let's go.
What day do we decide on that?
I don't know.
Yeah, we're a little testy. Everybody's a little testy. Let's don't start out. Everybody. I don't want to have to order y'all to hug each other this morning, but just let's be sick.
We already did hug.
Already hugged each other. Okay, that's more information than I want. I can tell you that.
Is it August 3rd?
August 3rd at 9.
August 3rd. August 3rd, you to be here for negotiation. August the 6th is your next court date. Okay. Bobby Fulton.
You need to make all next week.
Commonwealth versus Bobby Fulton, 26 CR 0044. Are you Bobby Fulton?
Yes, sir.
Good morning, Mr. Fulton.
Good morning.
You born in 1980?
Yes, sir.
Last 4 digits. Represented by Mr. Turner. What's the Commonwealth have in this case?
Well, Mr. Turner made a request this morning, meeting date case. I know how the sheriff feels about the case and that he was going to talk to the sheriff. I don't think they spoke about it. So I'd say you're probably heading for trial on this case.
What's the charge?
It's a wanton endangerment, multiple counts, shooting at home, allegedly repeated police officer.
Judge, actually, and the sheriff and I have played phone tag, things like that. I think he's open to talking to us about it. That's the reason I suggested the mediation. There's a lot of issues going on. We still have some outstanding discovery as well.
We need to check and see if the body cam say police, one can sheriff's office.
Okay, I'm gonna do it on August the 3rd. And
Judge, I apologize, but I'm not available August 3rd.
Well, you know, we're on a different date, but it's.
And that I'm out that whole week. It's been scheduled out that week for
the schedule is for trial.
Quite some time.
I'm not gonna let
Judge, I'm not
case like this drag out for
We're-
the
I'm
sheriff
not-
might decide something, but if there's weapons involved, The officers involved, even if the sheriff agrees to it, doesn't mean I would.
And we're cooperating with that, Judge. In that regard, I mean, if we set it for trial, it's
I'll
a
sit it
serious.
out a couple months.
Huh?
I'll sit it out a couple months.
In that regard, we're gonna have to have some investigation. We've been trying to resolve it. And we're gonna have to look into whether we're gonna need expert testimony as well in that regard. And I'm not gonna know part of that until I get to discovery. That's the reason I suggested mediation.
No, it's not gonna be mediation. You can talk to Commonwealth. You have these negotiation days.
Okay.
We don't have funds for mediators.
Well, unless he was waiting on
Yeah, I don't
that.
know if Pat's gonna approve anything until August.
If we can set it for another,
It's a waste of time to mediate this one. Y'all reach an agreement.
if we can set it for a mediation day in September, Judge, and that give
We
me
don't
time to
have
speak.
mediations. We don't
I'm
do
sorry,
mediations.
a negotiation day in September and a pretrial, then we'll either resolve it or set it for trial.
I set this for September the 10th. What's your negotiation day?
I don't know if I'll notify Mr. Tyron of the great order.
Okay. Both of those days. And we'll we'll either have an announcement that day or we'll set a trial date, and it won't be long out. The trial date won't be long out, okay? Okay, thank you very much.
Thank you, Judge.
Thank you, Your Honor.
Kenneth Gunter. Are you Kenneth Gutner? Good morning. This is 26 CR 0034. Mr. Gutner, were you born in 1968? Yes, sir. Last 40. Yes. What does the Commonwealth have to say in this case?
We need a negotiation on this one, and we do have one for September now, which will be August 28th at 9 o'clock. We set both of Mr. Turner's cases for that day, where he was going to resolve good trials.
August 28th for negotiation and September the 10th for the next pretrial. We'll have an announcement there, set a trial. Knox County, what time is Knox County scheduled?
Yeah.
You're not scheduled to come on for about 30 minutes. Could you turn the camera off till then? Great. We'll do it from here. We'll do it. Okay, thank you. Randall Hicks.
Alrighty, friends, now in hour 3 of TCF Live. So Gigi just put in the chat, negotiation is mediation, isn't it? Not exactly. Negotiation is a two-party situation where two parties talk it out and negotiate with each other, where mediation involves a neutral third party to help them with that discussion. That would be the difference there. Alrighty, keeping in this channel's promise of 9 to 11% more Judge Boyd, let's go to Bexar County.
All right, we're going to go on the record. Court is calling 2013 CR 11091 State versus Jesus Mancada. Could I have parties announced for the record? Could I have a file stamp, please?
Trey Maurer for defense.
And are you Mr. Mancada?
Yes, ma'am.
Did you review the motion to revoke community supervision and First Amendment motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same Jesus Mancada who was placed on community supervision in 2013 CR 11091 for the offense of forgery of a commercial instrument or check on June 27, 2017 for a term of 4 years? Is that you?
Yes, sir.
State?
On State's first amended motion to revoke violated condition number 5 in Bexar County, Texas, defendant Jesus Rodriguez Moncada did then and there fail to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2020 in violation of condition number 5.
How do you plead to that? True or not true?
True.
Violated condition number 5 in Bear County, Texas, the defendant Jesus Rodriguez Moncada did then and there failed to report to the supervision officer as directed for the months of January, February, March, and April 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True,
State will waive the remainder.
And that's 2-5. I'm sorry, 3 5s.
2 5.
2 5s. Okay. Did you understand by pleading true to any objections to the waivers?
No objection, Your Honor.
Do you have the court admonishments? Oh, I'm sorry, you gave it to me. All right, did you understand by pleading true to violation of condition number 5 and 5, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility and up to a $1,500 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violations 5 and 5?
Yes, sir.
Court will find 5 and 5 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement for the court's consideration is to grant state's motion, revoke community supervision, sentence to 1 year, and run concurrent with clause 2026 C008026.
That is our agreement, Your Honor.
All right. Are you asking the court to follow that agreement?
Yes,
Are you waiving your right to appeal?
yes.
All right. Probation. Was the restitution paid in this case?
Yes, Your Honor. I'm sorry.
Judge, I don't see restitution listed.
Okay. I know that was before your time when you were in this court. But there is $77 to Twin Liquors, $178 to Gabriel's Liquors, and $136 to Don and Ben's. Have you paid that?
Yes, ma'am. I paid that. I'm sorry, that was one of the things I was going to go on probation. That was one of the stipulations I had to pay before I was put on probation.
Ah,
And my attorney was George Shaver at the time.
let me see. Who's the person who took this plea?
I believe the
Yeah, Angelina.
Angelini.
Well, I know that was paid beforehand. All right, Miss Abrams. It was Angelini, so it was paid beforehand.
Yes, Judge, I don't have anything on his former conditions or anything that indicates restitution.
All right, and you're waiving your right to appeal? All right, the court is finding 5 and 5 true. The court will grant the motion, revoke. This is right concurrent with 2026 CC 008026. And counsel, you're saying that there's some issue with his wife?
Yes, Your Honor. My understanding is that my client's wife does have some healthcare issues, notably an autoimmune disease that requires some care. Obviously, my client is eager to get this time over with and move forward with his life so he can focus on being there for her.
And when you're drug tested today, what will the results be?
Negative.
Okay. All right, the court is gonna sentence you to a $1,500 fine, time and money run concurrent. The court will sentence you to 1 year in the Bexar County Jail under 1244. And I'm only doing that because I have seen the medical records in regards to his wife. I don't know if you're gonna be any help to your wife or if you're gonna take care of her the way you did not take care of your probation, but I've taken that in consideration.
Thank you, Your Honor.
And the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney, and they will take you into custody today.
Okay.
Thank you, Judge.
Thank you. Good luck to you.
Alrighty, friends, we'll keep an eye on her courtroom. Let's stay in Texas, but we'll go back to Judge Stevens.
Are you still at 5342? Yes, sir. Okay. So, Ms. Minaldi is here. This is an announcement. You know what you're charged with.
Yes, sir.
I think we went over this because there were some things we had corrected on, and you're no longer at 4215, right?
Correct.
Correct. I'm gonna mark through that.
That's my Bowler address.
The new one.
So now, so.
I think we went over what this was all about and also the punishment range applicable, which is up to 10 years in prison. Or a stalking case, and also, let's see.
Yeah. First week of August.
We were just trying to figure out which defense attorneys are going to be.
All right, you understand you cannot have any contact with this person?
Yes, right.
Who is the subject of the alleged victimization in this case?
Yes, Your Honor.
That would be catastrophic.
Yes, Your Honor.
Nor anyone in your behalf.
Yes, no.
What today?
Judge, I was retained on this about a month ago. I sat down and talked with Mike about the case yesterday. It was Ms. Gasper's case before she left, so I'm just trying to get a handle on kind of what we're looking at, but I believe Mike and I might be close to a different type of resolution. There's a couple things that he asked me to do.
You're close to a different resolution.
Well, there was an offer in the case, but we sat down and talked about the facts of the case.
I'm gonna speak to the complainant.
Well, I'm sorry, I misunderstood. A resolution different
Than
what had
previously.
originally been proffered.
Yes.
Maybe.
Yes.
All right, so what do you want to do today?
If I could have a week reset to accomplish that, that would.
We
Very
talked to the
helpful.
complainant and I may be in trial next week, so we may be in trial.
We
next week.
may.
In what court?
In here.
Here, Judge. Aren't you excited? See.
Y'all are. I thought I used to be allowed to determine.
No,
which trial I was going to go with, but-
we took a vote. You're no longer the.
This is.
You only invite me to the meeting? I mean, I can't even be a spectator?
No, we even voted whether you could come to the meeting or not, and it was, you were rolled out.
Serious case. Have you ever been in criminal trouble before, sir?
Not of this magnitude, no, sir.
Is that yes? I'm talking about, have you ever been convicted of a felony offense?
No, sir.
All right, fix this. Let's fix it.
We're working on, Judge.
Heed her advice. That would be wise.
Thank you, Judge. That's all I have.
Marcus Jimenez. Mr. Jimenez is where? There? Yes. It's 4-week day.
Mr. Laird. I'm sorry, I'm not. But never mind. I think it's gonna be the.
Don't worry with him. What do you want to do?
Well, I mean, I've already, if I'd known that, I just said dismiss it, but.
Seriously, you are Marcus Jimenez? You speak fluent English, sir?
Yes, sir.
Okay. You're here, Mr. Parker, very fine lawyer, is here, and the state, we've been through this before, I believe, because I've seen some resettings. And as you know, you are charged with a 3rd-degree felony of evading arrest or detention with a motor vehicle. A 3rd-degree felony carries with it.
It's a plea, Judge.
Up to 10 years in prison. Do you understand? Serious case.
Yes.
And we're disposing of it today?
Yes.
Well, then we're going to talk about it. Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about February 12th, 2026 in Jefferson County, Texas, you committed the 3rd-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with? Yeah, Antonio, you're clear. You know that. You can go. Keep up the good work on that.
Yes, sir.
Though. All right, thank you. You understand what you're charged with, sir?
Yes.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached in your case where you would be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $500, and there would be terms and conditions of probation, which were normal and customary and also particular for the circumstances of this case. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes.
Now, we call this deferred or unadjudicated probation. Have you ever been in trouble before?
No, sir.
All right. And I know Mr. Parker has told you deferred or unadjudicated probation means you would not be found guilty so long as you followed the terms and conditions of probation.
Yes.
If you failed, that happens from time to time here. Your probation could be revoked. You could then be found guilty. You wouldn't have a jury trial. It would be in front of the judge. And then you could be assessed the full range of punishment, no less than 2 nor more than 10 years confined in prison. That's why it's important to follow the terms and conditions of probation that you're going to be seeing here in a minute. If I follow this agreement, you have no right of appeal of your case. Do you understand, sir?
Yes.
How do you plead to this, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty of what the indictment alleges here?
Yes.
Going to show you what's marked as State's Exhibit 1. Did you sign that? Understand it?
Yes.
Discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
We waived that, Judge.
What are
We
we gonna do?
made a suggestion on the plea papers of 5 years deferred.
I saw that.
And,
I have no objection, Judge. I talked about it.
Is that okay with you if we reduce the term of probation from what we normally would do 10 years to half that to 5?
That'd be greatly appreciated.
Fix this. We also shorten probation by doing well to a third, which in your case, if I do 5 years, you're looking at 1 2/3 years. If nothing further, here's what I'm going to make the findings as follows. That you, Mr. Jimenez, are pleading guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this third-degree felony of evading arrest or detention with a motor vehicle. But I'm going to defer and postpone any finding of guilt so long as you follow the terms and conditions of probation here that I'm about to order and sign. There are 35 different terms and conditions of probation. The overwhelming majority of these requirements are what Mr. Parker has to do and what I have to do and what the state has to do, beginning with commit no offense. Avoid injurious habits. Don't associate with disreputable people. Certainly, this can't be hard for you to follow. I mean, these are things we have to do for the most part. There are other conditions that are specific, but when people say 35 conditions, my God, and actually there are far more conditions and requirements that you and I are required to follow and that we do follow because it's what's lawful and proper and courteous in dealing with others. So don't get shocked. There is one other thing. He's going to have to. I want a defensive driving or something here that he has to pass and take and pass. And I'm doing you a favor because your insurance is about to go up if it hasn't already. Your automobile insurance will go up for this. But on the other side of the coin, you take it and it will balance back out. And it's always a good thing. Okay, I've signed those and you are going to be placed on probation for 5 years. You're getting a break, make the most of it. Yes. Fix this and do better. Also, you're fined $500. All right, I think everything's set. Please see the probation officer.
Thank you. Thank you. Sure. Thank you, Mike.
Yeah.
Okie dokie, friends. Hour 3 of TCF Live. Good to have you all here with me today. I hope you're enjoying the show. I'm enjoying bringing it to you. Let's go back to Louisiana. New contestant in front of the board.
Hey, good morning. Mr. Dean, I'm not gonna try to pronounce your first name. So Mr. Dean, state your name and DOC number for the record, please, sir.
Good morning. My name is Quaterius Deontay DeMonier Dean II. DOC number 711735.
Okay, Mr. Dean, you're here today for a revocation hearing. My name is Pete Freeman. I'm the acting chair. Along with me is Ms. Renatzer and Mr. Steve Prater. We will be your panel today. Did you get a parole questionnaire?
Say it again.
You have your parole questionnaire with you?
Yes, sir.
Okay, do you realize you're not eligible for appointed counsel? If you wanted counsel, you'd have to hire him?
Yes.
Okay, you want to proceed today without a counsel?
Yes, you can.
Okay. All right, your case was assigned to Ms. Renatzer. Ms. Renatzer, I'll turn it over to you.
Thank you. Good morning, Mr. Dean.
Good morning.
So I'm going to read the allegation. You've been accused of violating the conditions of your parole supervision. So I'm going to read the allegation and ask you to enter a plea of guilty or not guilty, and then we'll talk about it.
Yes, ma'am.
So it's condition number 4, which says on March 1st, 2026, you were arrested for domestic abuse battery by Ouachita Parish Sheriff's Office. And on May 21st, 2026, you pled guilty to the amended charge of criminal mischief. You were sentenced to time served.
Yes,
How do you plead? Guilty or not guilty?
Yes, guilty.
And the next one is condition number 10, and it has to do with your fees. It says you were at the time this was written, you were behind $938.
Yes, ma'am.
How do you plead?
Guilty.
Okay, tell us what happened with the domestic abuse battery.
It really wasn't no domestic. It was like a person got mad, and it's between me and my daddy. Me and my dad had a disagreement at the house. At my his mom and my grandma at the house. I don't want to be foul with my word language. It was behind, like, we having words behind excuse my language, but split. And we having foul words, and as me as a child, I was using foul words, and it got out of pocket. Yeah. But it wasn't.
Yeah, it says you punched him.
Yeah, that was the lie he made. He supposed to came to court the day he was in jail. My dad is a drug head.
It says you punched him, then armed yourself with a knife and held it to his throat. And there was a witness who corroborated that account.
Yeah. That was the officer had told me, but nobody wanted the house but me and my dad.
All right. Well, tell us about your fees.
I try. I be try just like I end up having a child, and I picked the wrong woman. if you know what I mean. And I was working, but the job I was working wasn't no, it's like, I don't have permission for the work like that. It's only like, I only can work backup. Like, they cut the trees down. You got to have permission for to be around the trees because you can't be in when they fall down. And we just, after 4 until 6, we pick the limbs up for like $100 or maybe $200, like that. It's a contract. It's a little group. Like, he got a group of guys. It's my uncle. He comes to us, like, it depends on what's the contract about. Certain contract we can't invade about because the safety, however they break it down.
I see your supervision expires in next month.
Yes, ma'am.
Okay. Mr. Freeman, I don't have any other questions.
I have no other questions for Mr. James. Mr. Prater?
Is your dad in jail right now?
He was. I was told he came to jail for drugs. We got a thing that we can't talk or get near each other. So I just keep it like that for keep me safe and keep me not in trouble.
Thanks. That's it.
Yes.
All right, I'm ready to vote. Mr. Dean, I do find you guilty of violating condition number 4. You know, the account that we have in the record is different than what you say. So my vote today is going to be to revoke your parole. I'm glad there's a protective order to protect you and your dad from each other. Good luck to you, sir.
Mr. Prater?
Sir.
And Mr. Dean, I'm also going to concur. As you see, your expiration date is next month. So, you know, but you know, y'all need to make sure you try to stay away from him because you're the one who get in big trouble.
Yes,
not
sir.
him. Okay. Good luck.
Good luck.
Thank you.
So, Michael, thank you for gifting a membership. For those of you who don't know, and most of you should, but Michael Groff is many things. He is the guest host of this very program. He is a panelist on Sidebar, so you'll see him on the channel tonight, 8 p.m. Eastern, 5 p.m. Pacific. He is also co-host with me of In the Blind with Mike and Dan. He wears many hats, but as he just pointed out on his personal channel, he is only 77 subs away from 8,000. So, Barbara, would you do me a favor and drop a link for Michael's channel? And then if you would all be so kind as to go over there and sub to him, and let's see if we can inch him a little closer to hitting that 8,000 mark. Do me that favor if you would be so kind. Thank you very much. Okie dokie, where do we want to go? Let's go back to Judge Stevens.
Thank you.
And we now call cause number 24 CR 1885, the state of Texas versus Kataya. Is it Llanos Castillo? Okay.
Yes.
That is you. It's that. Do you speak English fluently?
I understand the majority of it, but not all of it.
Are you a citizen of the United States?
No.
Are you becoming a citizen of the United States? Are you in the process?
No.
No. Good. Okay. Okay, I have Miss Birch here, who's going to be the translator because she speaks fluent English and Spanish and probably 10 other languages because she's a really smart lady. And she's going to help you understand what's going on. I will be speaking English and these gentlemen will be speaking English. It will be translated into Spanish, the language you understand best. Your answers will be translated by Miss Burge from Spanish to English so all of us and the court reporter can understand what you are stating. Do you understand? And Ms. Burge, please raise your right hand. Do you solemnly swear or affirm? God bless you. Good trick. It does look right when you're on the YouTube. Do you solemnly swear or affirm that you will well and truly translate from Spanish to English, Spanish being the language that the defendant understands, to English, so all of us here involved in this case who don't speak Spanish and the court reporter can understand. And then you will interpret Spanish not only to English, but English to Spanish, so that the defendant can understand the English that is being spoken and addressed to her, and you will do that accurately. So help you God.
Yes, Judge.
Over your head. Thank you. And thanks for doing this, as you always do so well.
Yes, Judge.
Does the defendant waive a formal reading of this indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
Hold on for just 1 second. Let me. This indictment is carrying with it a
there's an attachment.
Yeah, it's what's petitioner supporting affidavit, which I guess is the substance of the alleged perjurious statements.
That's correct, John.
All right. The defendant is charged in this case with the 3rd-degree felony of aggravated perjury. In summary, this indictment, wow, which was handed up by the grand jury on September 11th, 2024. That's old. I'm glad we're finally getting this thing disposed of here. This states in the indictment that on or about March 27th, 2024, in Jefferson County, Texas, you, Pitaya Llanos Castillo, with intent to deceive and with knowledge of the statement's meaning, you swore to the truth of a false statement. And that statement is what's referred to as the petitioner's supporting affidavit, that states that you, Pitaya Llanos Castillo, as petitioner in a court here in Jefferson County, Texas, a district court, in a matter concerning the interests of children whose initials are ES and AS, that in that affidavit that you swore was true and correct, you stated that you were the petitioner in the case. You have an agreement in place with your children's father, Laureano Sola Gomez, that he would have visitation every Sunday from approximately 8:30 a.m. to 9:00 p.m. on that same day. And on January 28th, 2024, you drop your children at his residence as you do every Sunday. We had decided that my son, according to this affidavit, that you signed, we have decided that my son, Emilio Sola, would stay with his father for the night because he did not have school the next day. And I was to pick up Alani Soloj. Solo. How do you pronounce Soloj in Spanish? Is the J silent?
Solojo.
Solojo, like an H. It's an H sound. Okay. To take her to school the next morning. You went on in your affidavit to state that he initially told me he was going to take the children to a party. I went to pick the kids up from their father, and they were not at his residence. When I got there, I called multiple times. Laureano Gomez finally answered the phone and told me he was having the kids checked out in the hospital, claiming I had abused the children. I have never abused my children. I was able to get my daughter from him and take her to school. And this statement goes on further, which ends with the only time since he had taken the children away from me that I was able to talk to them or see them was this day on February 16th, 2024. So what this apparently boils down to was a statement you made, an affidavit under oath dealing with your relationship of the children and visitation and possession of the children with your husband or ex-husband. I don't know, the father, the children's father. And apparently, according to this indictment, this statement, this affidavit that you signed under oath contained false statements or a statement regarding Laureano Gomez forcibly taking the children away and not allowing visits. And that was a false statement that you made. And that affected the custody relationship of the children, which was being handled out of the 317th District Court of Jefferson County, Texas. Do you understand what you were charged with in this indictment?
Yes.
If convicted, this is a third-degree felony, and you are facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand the seriousness of this case in regards to the punishment that can be assessed?
Yes.
An agreement has been reached that you would be pleading guilty, not found guilty, but placed on deferred or unadjudicated probation. And this can be up to 10 years in length. I don't see a fine. There is no fine here.
No fine, Judge.
Is this your understanding of the agreement?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this charge, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document? Understand it?
Yes.
Discuss it with your attorney? And are the contents all true and correct here?
Yes.
State's Exhibit 1 is tendered into evidence. Without objection, it's admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you guys.
Yes.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Please, Your Honor.
Okay. What are we saying about the length of time, State?
I don't have any objection, Judge. She has no priors. This was a matter involving custody issues and a divorce, so I think things got carried away.
Do you understand this seriousness of all of this matter?
Yes.
Are you certain?
Yes.
Okay. What has happened here by not being honest and truthful You have put yourself in a difficult position in this arrangement with the children and your ex-husband in this divorce case. Number one. Number two, you're not a citizen of the United States. And this can affect your ability to become a citizen. Number three, this is aggravated perjury. Aggravated perjury may be one of the most serious crimes, because if you're convicted, you are represented as a liar the rest of your life. Nobody wants that. You understand how important it is to be honest. In your case, it affects you in several serious ways. That's what we all should live honestly. But you have a lot to lose by not being a citizen. Immigration and customs could do something about that if they want, because this is a felony offense. You're not found guilty, but you pleaded guilty to it. Also, it's not going to help you in the divorce case and getting privileged visitation with the children, because judges need to be able to trust the people who are before them when the judge makes orders. You have to follow the order. And also, once again, perjury, it stamps you as somebody dishonest publicly. That's terrible. You don't want that. But you know right from wrong, truth versus lie. Live honestly. You have a lot at stake, as we all do, but you especially, as it can affect your citizenship here in the United States, among other things, and the relationship you're going to have with your children during this divorce. Fix this. Oh, there's only three things people have to know. Live honestly. Harm no one. Give each person due respect. Three things. All law is based upon one, two, or all three of those. So you don't have to memorize all this. It's only three things. We can boil it down to three things. And these three are all part of what you're involved with right now. Okay, fix it. If nothing further, I'm going to find as follows: that there is sufficient evidence supporting this agreement for me to grant it. I find that the defendant has pleaded guilty voluntarily. She is mentally competent to do so. You understand and appreciate the consequences of pleading guilty. Even though there is sufficient evidence supporting her guilty plea to find you guilty, I am not going to find you guilty. Instead, I'm going to defer or postpone any finding of guilt so long as you follow the terms and conditions of probation that I'm going to sign. Make sure you do. If you fail, your probation can be revoked. I can then find you guilty, and you can be punished up to 10 years in prison. Plus, you would be labeled a liar, a dishonest person for the rest of your life. You don't want that. And also, you're a mother. You have to set examples for your children, which include being honest so that your children learn to be honest, right? Okay.
Yes.
This is going to be for 2 years. And I don't see, there's no fine. No fine. Let me see terms. I think there's something that needs to be done to report and inform immigration and naturalization about this. So, because I don't know if they would normally know about it, but they have, she's being, I'm sure supervised like all resident aliens in the United States by immigration. And they need to know about what the status is here, I think. Because they're not necessarily going to know. I don't think that's going to affect what anything they would do. But I was in the federal government for 20 years and we don't know everything that's going on out in the other jurisdictions and all the time, there's a lot we did know, but this could affect your immigration status. You have to know that in all fairness, but you're not found guilty. And that is one thing going for you, but fix this, do better. See the probation office sign and you begin probation. Do you understand what has happened today? All right, thank you.
Thank you.
Alrighty, friends, in our final half hour of TCF Live on this fine Thursday. It is good to have you all here. Let's go back to Louisiana around, 2 or 3 at the board? I think this is our 3rd one for today. Depending on the length of it, we'll probably finish the day here, but we'll see.
Okay, good morning. How you doing, Mr. Morris? My name is Pete Freeman. I'm going to be your chair today. Along with me on the panel is Ms. Sharla Brown and Mr. Steve Prater. Would you state your name and DOC number for the record?
Marcus Morris, 492928.
Okay, Mr. Morris. Do you have your parole questionnaire with you?
Yes, sir.
Okay, you understand that you're not eligible for appointed counsel. If you wanted to have an attorney, you would have to hire him?
Yes, sir.
Okay, you want to proceed today without appointed counsel, without counsel?
You want to proceed without counsel?
Yes, sir.
Okay, your case has been assigned to Mr. Prater, so I'm going to turn it over to him. Does he have to?
Okay, Mr. Morris, are you doing okay today?
Yes, sir.
Okay. I know you got 3 people that want to speak on your behalf, but let's go over a few details right quick first. You're charged with domestic abuse battery from 4/10 of 2026, which was a misdemeanor, and you've been in jail now since then, correct?
Yes, sir.
And have they done anything with the case yet?
No, sir, I haven't been to court yet at all.
Okay, hadn't had a court date at all. And according to the report and according to everything on here, you and the lady that you are, y'all are living together, correct? That's your
Yes.
fiance?
Yes, sir.
Same address, are y'all still living together?
Yes, sir.
Okay, I noticed on the report that both of you are listed as victims and both of you are listed as suspects. And
Yes,
there's no mention of any injuries to anybody, and that y'all both say that it was simply, it went from a verbal altercation to where there was some pushing and shoving. Is that correct?
No, sir. I never put my hand on a woman at all.
Okay, but that's what the report says.
Yes, sir.
Okay, and so you're pleading on number 4, condition 4, which is what you're charged with violating by being arrested. And on that arrest, you're saying that you are not guilty of having done any domestic violence against this lady, your fiance.
Yes, sir. She on here.
Okay, and we're gonna hear from her in just a minute. I just wanted to make sure that, and there's no injuries or anything. There wasn't any listed in the report, no signs of any kind of injury. It's just a misdemeanor charge that you're charged with. Y'all are still together?
Yes, sir.
Still planning on getting married?
Yes, sir. We talk to each other every day.
Okay, all right. And your full-time date is next year. You're getting out then anyway. So let's talk to her right quick then. Let's go ahead and get your fiance, Kianca Taylor. Kiancia Taylor. I'm saying that all wrong, I'm sure, but Miss Taylor, would you tell us what's on your mind?
Yes, sir. It was a verbal argument and it never got physical. I even have a video of me when I got released out of jail. I went to work like maybe an hour later, and I have a video of my face, my hands, all my nails were still on. It never, and I tried to explain to the officer, it never got physical. My sister was in the house on the couch. She had just had surgery, and she just heard us get loud, and that's why she called the police. When the police arrived to the house, DeMarcus was already back in his car, parked at the dead end, and I was in the house. I came out when I seen the police. It never got physical. And his job even wrote a letter on his behalf stating that they will let him come back to work and how good of an employee he was. I gave that to Miss Buster, and I have a copy myself.
Okay, good. All right, well, let's hear from
Got a question, sir, Mr. Pray.
Excuse me, I'm sorry. Yes,
I'd like to ask her a question.
I'm sorry.
Ms. Taylor, is this the first time y'all have had problems like this?
Yes, sir.
It's the first time he's ever been arrested for domestic violence against you?
Yes, sir.
Okay, thank you.
You're welcome.
Okay, Bobby Taylor, would you talk to us, the son-in-law, and you can be brief. Just tell us what you know about this incident, please.
Won't see her on there.
Okay. Okay, did I do it? Okay.
Yes.
So, I mean, he's a good person. He's a changed person. He works. And I just see that was just a misunderstanding. This happened. This is just a misunderstanding. Because he go to work. He don't hang out. He's a good person. Good person, hard worker.
Okay.
And this was just a misunderstanding.
Okay, so you a character witness then more than anything. Okay, thank you very much. We appreciate that. Now let's talk to Jared Lofton, who is a cousin. Mr. Lofton, are you on there, Jared?
Yes, sir, I'm here.
Tell us what you know about him.
Yeah, so I'll be a character witness as well. That is my older cousin. I remember, for one, when he was incarcerated, and I talked to him throughout that duration. When he came home, he was telling me about all of the different things that he would do. I'm gonna work offshore. I'm gonna make sure that I'm raising my kids, and I can attest to the fact that he did all of those things. Shortly after he came home, he wanted to get his driver's license. Within 3 months, got his driver's license. Started working. He went from one job, ultimately got to another one that was kind of a lateral move. Stayed out of trouble. His probation officer, I think her name was Miss Dartha Bustard or something of that nature at the time. Spoke highly of him, like he never got into any trouble. And I definitely do believe that he's great to be released. He definitely has our vote to be released if it counts. Definitely appreciate that.
Thank you. Appreciate that very much. Mr. Morris, back to you. I think you're the last. Talk to you one more time. Mr. Morris, you understand now, and I'm not saying how I'm going to vote or how the board's going to vote. I can't speak for them. But if we were to release you from this hold that we have on there, you see and you understand how quickly things, how because of your record, you can be in trouble real quick. You understand that?
Yes, sir.
And how you've got to avoid anything like this. And I'm speaking really to both of y'all, because we can't have the police coming over and getting involved, because you're going to get the wrong policeman. Like, I'm not saying this is what happened, but I know police sometimes get there and the safest thing for them to do is lock everybody up and send it to court. Yes, and that's okay. That's not okay, but that's not so bad if you aren't on parole. If you're on parole, it turns into a very bad situation.
Yes.
Just the fact that you're locked up. So you understand that, Mr. Morris?
Yes, sir.
Okay. That's all the questions I have. I'll turn it over to the board to.
Ms. Renata, you have any questions?
I have no questions.
I have no questions.
Okay, Mr. Morris, I think that as far as your parole goes, I think that we're gonna go ahead and just continue you on your parole as far as what my vote is. That'll be up to the rest of them. But I want you to go and sin no more, as the saying goes. And be very careful. Be very careful what you do. Avoid the appearance of impropriety.
Yes, sir.
Ms.
And my
Renata?
vote is do not revoke.
My vote also is do not revoke. Good luck to you, Mr. Morris.
Yes, ma'am. You too.
Okay. Mr. Morris, I agree with my colleagues. My vote is to do not revoke. And y'all may want to get a little counseling or something. You know, you're going to be married. Like you say, a little argument can put you in jail.
Yes, sir.
So good luck to you, sir.
You too, sir.
Well, alrighty then. We end on a reinstated. Good way to end the show. All right, my friends, we will be back tonight, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel for Sidebar. Do join us for that. If you haven't watched Sidebar before, you need to, because, yeah, it's a discussion show about court stuff, but this is a show that was made by the audience. This was not my brainchild. This was several people that we see in the chat every day coming to me going, we want to do a show. And that makes it special. So if you haven't checked it out, please do check it out tonight, 8 p.m. Eastern, 5 Pacific. And we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you are a channel member. The wisdom I leave you with today is from Aristotle. We are what we repeatedly do. Excellence, then, is not an act, but a habit. I find those to be very true words. Go have yourselves a great day, friends. We will see you soon. Take care. God bless.